Good afternoon. Good afternoon, Mr. Codreanu. Sorry for starting a bit later due to an earlier hearing that took a bit longer than we had expected. But good afternoon to all participants in the online public hearing organized by the Independent Evaluation Commission for assessing the integrity of candidates for the position of member in the self-administration bodies of judges and prosecutors pursuant to law number 26/2022. I hereby declare this session open. This hearing involved the resumed evaluation of Mr. Vitalie Codreanu, candidate for the Superior Council of Prosecutors and prosecutor in the Anticorruption Prosecutor's Office. I would like to welcome you, Mr. Codreanu. We are here.
Bine v-am găsit.
Okay. We're here to
Happy to be here. Greetings again.
Yep, thank you. We're here to conduct an online public hearing in the context of the resumed evaluation process aimed at assessing candidates for the position of the Superior Council of Prosecutors. The Commission is acting in accordance with law number 26/2022 and its rules of procedure. On the screen in front of you, you have the 5 members of the Commission: Victoria Henley, Nadezhda Rybczewski, Tatiana Raducanu, Nona Tsutoria, and myself, Herman van Hebel, the chair of the Commission. The Commission is also assisted by members of the Secretariat, and the online public hearing can also be followed by representatives of the media and the public. And those representatives are advised to shut down, to switch off the cameras and to mute their microphones. During the hearing, interpretation between Romanian and English will be provided, and to allow for accurate interpretation, I would kindly ask you to speak clearly and slowly. Furthermore, the proceedings are being recorded and the public parts will be available online, generally within 24 hours after the hearing, via the website of the Commission, www.vetting.md. I will start with a brief overview of the procedural background of this resumed evaluation. On 15 May of this year, the Commission issued a decision in relation to your integrity evaluation for the position of member in the Superior Council of Prosecutors. In its decision, the Commission decided that there are serious doubts about your compliance with the criterion of financial and ethical integrity in relation to, on the one hand, the use of a preferential price housing program for prosecutors to assist the purchase of property for a family member, and the second issue, the method of acquiring a 49.1 square meter apartment as service-based housing and privatization of that housing. On the 9th of June, you appealed this decision to the Supreme Court of Justice, and on 1 August of 2023, the Supreme Court of Justice annulled the Commission's decision and ordered a re-evaluation. On 8 September, the Commission started the resumed evaluation, and on 16 October, pursuant to Article 19, Paragraph 1, Littera C of its Rules of Procedure, the Commission sent you a statement of facts and serious doubts. On 26 October, you responded in writing to the statement of facts and serious doubts, and on the same date, you also informed the Commission that you wished to participate in a public hearing. By then, you also requested the Commission, pursuant to Article 19, Paragraph 1E of the Rules of Procedure, to hear a person to address an issue about which the Commission has indicated it has serious doubts. The Commission has accepted to hear this person, and you have identified the issues about which the person was proposed to testify. The Commission will hear this person later during this public hearing. During this hearing, the Commission will take into account your privacy and, where required and possible, the privacy of your family members and close persons. So we will leave out unnecessary details relating to, for example, ID numbers, bank account numbers, addresses of real estate, and the like. For the protection of your own privacy, we ask you to do the same. The present hearing takes place at your request, and the hearing will be focused on the statement of facts and serious doubt that the Commission has sent to you and your written response to the statement of facts. The Commission would like to invite you now, if you so wish, to briefly provide additional explanations to complement your written response to the statement of fact and serious doubts that you submitted to the Commission. I urge you to be concise in your explanations. You will be given a maximum of 50 minutes for each of the issues mentioned in the statement of facts and serious doubts. Afterwards, one or more members of the Commission may have questions for you about the explanations you have provided. In case we will have any questions for you, we will try to keep them short and to the point. We ask that your answers be short and to the point as well. We also ask you to answer all questions truthfully and completely. Your explanations are, as you understand, important to the Commission in verifying your financial and ethical integrity. I would like now myself to start the discussion with you on the statement of facts and serious doubts. As I mentioned, we have two issues to discuss this afternoon in the hearing, and the first issue relates to the use of preferential housing program for prosecutors to assist the purchase of property for a family member. As I mentioned, on 16 October 2023, the Commission sent you a statement of facts and serious doubts in relation to the two issues I mentioned earlier. In relation to the first issue, the Commission provided the statement of facts and formulated its serious doubts as follows, and I quote, "The Commission has serious doubts about the financial and ethical integrity of the candidate in that he made use of a preferential housing program for prosecutors in order to allow his parents to buy an apartment for his family member at a lower than market price, despite the fact that the candidate's family member was not eligible to participate in the program. Serious doubts also exist in relation to the fact that the candidate never informed the Prosecutor General's office that his participation in the preferential housing program was not to improve his own housing situation, but was to benefit his family members. Serious doubts also exist that the candidate did not meet the eligibility criteria of improvement of living conditions, personal investment in the construction of an apartment, and full transparency in participation in the program, and thereby use public funds aimed at improving living conditions for prosecutors to benefit his family member. To benefit his family member in buying an apartment against a lower than market price. In addition, serious doubts exist relating to the sale of the apartment to this family member in 2013, as there is no proof that any transfer of funds took place in relation to the sale of the apartment, contrary to the candidate's representation in the sale purchase agreement. As I mentioned, on the 26th of October, the Commission received your response in writing to the statement of facts and serious doubt. And the Commission has, of course, taken note of your responses. If you so wish, please briefly provide additional explanations to complement your written response to the statement of facts and serious doubts. As indicated, you're provided a maximum of 50 minutes to further elaborate on this issue. So if you would like, please go ahead, Mr. Codreanu.
Mulțumesc foarte mult. Aș vrea să încep de la aceea că
Thank you very much. I would like to start from the fact that certain circumstances are known to me today, but were not known to me at the time of the first rounds of questions or at first stages, and at the time when we had the hearing. Recently, I found a matter that the Commission did not know, and I think that this thing will turn over the opinion of the serious doubts that the Commission claims to have. And I would like to start from the fact that this program that was mentioned was and represented a program not just for prosecutors, but also from their family members. I during the first hearing and in all the rounds, I communicated that my sister at that time, and that is year 2010, not 2008, and I will correct that mistake or mix up that both I and the Commission had. That year, 2010, both my sister and I were living together with our parents, and we were one family. So our budget, common budget, it wasn't a separate budget for each of us. We had a common budget. So myself, my sister, my parents, we were taking part in the current expenses of the family, and I believe that these suspicions that the Commission mentioned about parents' money used for my interest and for the interest of me and my sister are not true, because money, in principle, was money of the family, and as a subject of declaration, I was not obliged to mention in the 2012 declaration the income of my parents. And I believe that that budget was valid, or I could have used it as well. Speaking of the money that was used to buy that preferential price apartment. At that time, my sister was divorced. I was not married. And in order to improve the living conditions, my living condition as well, by separating our sister from our family, the family decided for me to benefit of that program, to take part in it, and to be able to somehow separate the life of my sister from my parents and my life. I think that was an absolutely normal intent. It was not used for personal purposes in order to harm interests or rights of third parties. And I will go later, because there were no complaints about the Commission's decision to issue me that apartment, to assign that apartment to me, but that I will do later. At that time, the Commission, when it looked into the documents and the application to assign me this possibility to purchase an apartment at preferential price, did not ask other information from me. It did not ask if the final beneficiary is another person, a third person or a family member. It did not ask for documents related to the existence of some court decisions that would allow service housing being assigned to me. I know that out of those apartments, several apartments were purchased by my colleagues for their children, and it was natural for parents, prosecutors, to buy housing for their children who were minors or of full age, it depends. And I did the same thing. I believe that this situation can be applied to me as well, given that my sister was a member of my family. Now, recently, and I asked the Commission to attach that to the evaluation materials, I found one thing that I did not know before, and I couldn't have known it. And I'd like to explain that in the first round of questions, and when we had the hearing, I did not have the contract called Complex Contract Number 172 of 25th November 2010. I submitted that contract on Monday or Tuesday. I submitted to the Commission to make sure that to make clarity that this program that I took part in was established by an order of a Prosecutor General of 2009, if I'm not mistaken, December 2009. Therefore, the investment contract could not be from 2008, because otherwise it's a bit unclear. How could I have taken part in a program of 2009 and signed a contract in 2008? I did a quite a lot of thinking on this topic, and I couldn't find the documents, but recently I obtained them, and I found that actually it was a program of 2009, not 2008, and the contract was concluded in November 2010. Also, for this purpose, I submitted a copy of the receipt of 25th November 2010 when the contract was concluded. And I'd like to say that the Commission's doubt regarding the fact that in 2008 or in 2009, when I went to the Chisinau Court of Appeal as a first level court to get service housing, that contract did not exist. It did not exist physically, it wasn't registered, I was not part of that process or the company that built that house. To make it clear, the Commission raised a doubt that I, in 2008, having concluded an investment contract for that housing, I also used the provisions of the law that allowed and obliged the local authority to provide service housing, to provide housing for prosecutors. And by middle of this contract that is dated 25th November 2010, I want to show to the Commission, and I hope that this information will be analyzed, that initially I asked the Chisinau Court of Appeal for service housing to be assigned to me, and after some time in 2010, the Court of Appeal decision is in April 2009, but in November 2010, 1 year and a half later, only then the investment contract was concluded, and only then that contract dated 2008 started to produce effect. I mean that in 2009, I did not have an investment contract. I was not benefiting of hypothetical housing that was going to be received by me or my family in some future. It did not exist. Now I ask this question, and probably this will be a question for the Commission members as well. How was it possible to conclude a contract valid for 2008 if I support the hypothesis that this contract of 2010 generates legal effect? And I can explain that. I will go back to another matter. This thing is quite complex. In 2009, when the Prosecutor General established the Commission, the land plot allocated for construction was on Melestiu Street. And that project was supposed to be put in practice until 2016 or 2017 to build the housing. I submitted a suggestion to the construction company and to the Commission members to have an exchange of location, meaning my right to the apartment on Melestiu Street, a project that was starting in 2009 or 2010, to be exchanged for an apartment that the company already had finished. The company offered several places in Buyucani, Râșcani, or Ciocana sector. I chose Ciocana sector because that building was in the neighborhood of where my parents and I were living, so it's my entire family, and it was, of course, very comfortable to us to be next to each other. Most importantly, that building was almost finished. It was put into operation. The project of 2009 that I was supposed to be part of, it was only starting, and then all of us, or some prosecutors, discussed there is the risk that these buildings will not be finished, that we will be conned, that we will be just left without our money. So for me, that was an extremely favorable option to be able to obtain, instead of a future right, to obtain a real apartment in a short time, in this year or next year, that was already finished. And that apartment was not property of the local public authority on which the building of the project of on Melistiu Street was built. So that land plot was property of the construction company or people who invested in it. So that building was outside of the project started by the Prosecutor General of the order with the order of 2009, April 2009, if I'm not mistaken. Sorry, December 2009. I believe that the insurance company, so that we could make this exchange, suggested and offered me a standard contract that they had concluded with investors for that housing space in Ciocana, for the ones met in investors, not for prosecutors, for investors that invested money starting in 2008. So they gave me that contract. I signed it. I accepted those conditions. And that contract was registered with the Territorial Cadastral Office. That's how all this misunderstanding appeared for me and for the Commission, which believed that initially in 2008 I had this housing through an investment contract, and then I also benefited from the law that obliged the local authority to provide me housing. That is absolutely wrong, and that doubt that the Commission raised in this respect is reverse. I first accessed or I first used the provisions of the law on prosecution that obliged the local authority to provide housing based on a decision of a court of appeal that again has not been enforced for more than 5 years, but I did not have that housing because the Commission interpreted that I already had some housing and I was using another right as well. So the situation was opposite. So I would like to ask the Commission to pay attention to that, because the money for that contract that I make reference to, which is registered with the Territorial Cadastral Office in 2008, that money, the money for that contract, was paid in November 2010. And the payment order says payment for housing as per contract 172 on Mircea cel Bătrân 20-6. This contract number 172 of 2010. With respect to the fact that, well, I noticed that the Commission raised an issue about the use by me using public money by means of accessing this program. Esteemed Commission members, I am sure with respect to this issue and others that result from it, I asked for a witness to be heard, Pascal Andrei, who is or who was actually the secretary of the Commission. To this end, I provided the answer to the request to the Prosecutor General Office that show that the documents regarding the activity of that commission were not kept, but the person responsible for their storage was Mr. Pascar, being the secretary of the commission. I noticed that the Preventing Commission tried to ask for these documents from the Prosecutor General Office, and the Prosecutor's Office told you that the documents are not available, and I don't understand why, in the opinion or in explaining its opinion, the Commission asks for these documents from me. I explained I don't have them, but I proved my good intention to find these documents. It wasn't very clear for me, but the Commission unfortunately believes that I did not submit it and I didn't do all due diligence to present confirmation documents in order to confirm the circumstances of obtaining this apartment and in relation to that program altogether. Neither the Commission nor I could find these documents, but the money used for building the building of that complex were investors' money. It wasn't institutions or budget money, central, public, or local. It wasn't money from the budget. I just believe that the land plot was allocated by the City Hall to the prosecutor's office in order to build that house. I don't know what were the conditions. Was it for free or was it against a charge? I don't know what the conditions for assigning that land plot was. But in that case, myself and any other prosecutor that took part in that program did not use public budget money or institutions' money. I explained that actually improvement of living conditions, that program is not only meant for prosecutors, but also family members. So my sister was a family member. I don't believe that in this case or in this situation, I somehow violated ethics by helping a member of my family, thus creating better living conditions for me. In a way, I mean, it's one way when in an apartment you have 4 people living, and it's different when it's fewer people living in an apartment. It was an improvement in living conditions anyway, and in any way, the public budget was not damaged in any way in this case. Regarding damaging to third parties, I would like to inform you that during all the years and until today, no one ever submitted any complaint or request regarding that program and payment of those sources. I mean, I hope the Commission understands, and I believe that in this case, the prosecutors that asked for housing purchased from their own money at a preferential price because they were the investors, they were not harmed. The ones who wanted to take part did take part. From what I know, that program was meant for prosecutors from Chisinau municipality. I don't know what were the ways, but I would like to find that out from Mr. Pascal, how they examined the applications, what were the eligibility criteria, but I believe that I was also a candidate, a prosecutor that was eligible to take part in the contract, even though I was taking part in it based on our common budget and for the improvement of living conditions of a family member. With respect to the sale and purchase, I mentioned in the previous meeting or in the previous hearing, and I would like to declare that again now, that contract did not result in any people incurring harm. That contract has the intent to produce legal effect for me and my sister. By means of this contract, we did not have the intention to make profit or decrease the profit deliberately, and no discussion was about transferring money from my sister to my parents when that apartment was sold. It doesn't make sense for that apartment purchased from a common budget to be paid back to the common budget by my sister. I want Commission members to understand that. There is no proof of money transfer. It didn't make any sense to do that. It was not done to obtain the money or to make an income out of it. In the previous meeting, I made reference to articles of 190 and 191. And the same legal provisions as the Commission mentioned are valid for year 20, starting with 2017, based on amendments to the Civil Code. But these amendments at the time of 2013 were valid as provided for in Article 221, and I would like to read that so that you would understand that the contract is valid, is perfectly valid. Article 222, fictitious.
Da, mă scuzați. Mă scuzați. Nulitatea
I
actului
ask him
juridic.
to read. So, nullity of fictitious or simulated legal act. Paragraph 2. The legal act concluded with the purpose to hide another legal act, a simulated one, is void. with respect to that, these rules will be applied. Paragraph 3, in case the good acquired based on a fictitious contract, it is being transferred to a third party with good intentions, that it will be perceived as this third party in this case is my sister. And I think in these conditions, this third party is of a good intention and the transaction was well intended. So according to the legal provisions at that time, they were absolutely valid, producing effect, and the national authorities recognize that contract. Therefore, I don't understand why the Commission somehow connected its doubts to the legal provisions as well. The law allowed and expressed somehow the possibility for the existence of such contracts. Legal relationships are various, varied. As in our case, sister and brother, we had good intentions, and this change of owner by the contract, and I explained it in the previous hearing, it took place in connection to my marriage. In 2013, I got married, and in order not to create any issues or problems, it was something absolutely normal and logical. As I was the de jure but not de facto owner, it made sense for that apartment to be transferred into ownership of my sister, and no problem was caused by that. No problem for me or for my sister, and the parents insisted to avoid misunderstandings over time. It's better for the sister to have the proper documentation, and this is what we did. And no intention to violate norms or to avoid paying taxes to the budget or something. Nothing like that existed. We, family members, we are still owners of that apartment. The sister lives there until now. It's clear and obvious that the intention from the very beginning was achieved, and it is valid until now. I don't understand why the Commission members believe that helping my relative, and it's a first degree of kinship relative, is a disciplinary deviation. And the Commission made reference to the Code of Ethics in 2007 to 2011 as a deviation. I don't understand, even though the Supreme Court of Justice in its decision of 1st of August 2023 declared that unjustified and made reference to the provisions of the administrative code that mentioned the kinship degrees, and explained that in a country as Moldova, kinship degrees are something absolutely normal, and relatives are maybe not obliged, but they have to help each other. Of course, not to the damage of other people or third persons, or to the damage of the state. The Commission did not submit me any circumstances. I mean, the decision of 15 May of the Privating Commission. The Commission did not show me how did I damage, who did I damage, what person, a name or a state entity. That does not exist. With respect to not declaring that apartment, I declared that back then, and I will repeat that, and I hope you will understand me correctly. Indeed, I did not declare that apartment in 2012 because of not knowing, because that declaration of income of assets, it was the first time that I filled it out. We did not know how to do it. No one consulted us on that. No one explained. So, and I was thinking that since I am not the de facto beneficiary of the apartment, I wasn't supposed to mention it in the declaration of assets. And I did not do deliberately. And this is confirmed that in the next year, in 2013, when I sold that apartment, I showed it in my asset declaration. I showed the sale purchase contract. I did not intend to hide that property in 2012. It didn't make any sense to show it next year with a sale purchase contract and to ignore the legal provisions. I would like to make reference to other decisions of the pre-vetting commissions as well, and please understand me correctly, esteemed commission members. I don't make any...
Mr. Codreanu, can I please interrupt, because we indicated that we would give you about 15 minutes. I think we are now nearly close to probably well over 20 minutes for you to provide information. You have provided some new information that, of course, the Commission will look into in how to include that in our further decision making. As far as comparison with other cases is concerned, of course, the Commission will do so itself as well. Obviously, we are obliged to provide for recent and consistent decisions. Is there, in relation to this issue, anything else of a factual nature that you would like to share with us? Otherwise, I would propose that we get started with asking questions to you. Please go ahead.
Sorry,
I would like to finish my idea. Just 1 minute, not more.
Sure.
And this idea was like the final part of my speech on this subject. I would like to say that I did not have the intention to hide this property from my declaration. While other candidates that the Commission passed, there have been found cases where the prices for certain real estate and other goods were underestimated to an extent or another. I mean, either decreased or increased prices, it doesn't matter. But in those cases, the Commission decided that those candidates are not reaching the level of serious doubt. I would like the Commission to during the evaluation, to take into account the intention and imprudence. If the Commission believes that I did that deliberately, then I don't think another decision than failure could exist. But I, with all certainty and dignity, declare that this was an omission. It was a mistake. It was not done intentionally. And please put it on a balance. When someone deliberately did not do something and then the Commission found it, but the candidate ended up with being passed. Thank you. I am done on this topic.
Okay. Yeah. Thank you very much, and sorry for interrupting. But of course, as you have provided some new information, some new presentation of facts, etc., we will of course consider this further in our deliberations. Of course, I had a few questions to you, because I still think there was a document signed by you on the 15th of May 2008. What was that document? What was the status of that document according to you? Because you indicate that the first documents were only signed in November or December 2010, but we do have a document signed on 15 May 2008. So what is, in your view, the character of that document?
I would like us to start from the origin of this issue. I couldn't have participated in the program of 2009, established by the Prosecutor General by an order in 2009, for events that took place in 2008. Do you understand me or not? It wasn't possible for me to have signed the investment contract in 2008 while the program started in 2009. That is not possible. Logically, that can't happen. And I have an explanation. I explained that once more. That contract of 2008 was a standardized contract given to me by Basconslux company, because they, Basconslux, somehow put me not into the Prosecutors General Investment Program, but an investment program of their own, a separate one, just for any individual that wanted to buy housing in a block of flats. And I explained again why I did that, because in 2009 or 2010, the construction had only started there, but Basconslux offered me housing that was already finished. It was more favorable to me to get the housing that was finished instead of taking part in a project, even though I was selected based on that project of 2009. And the Basconslux company gave me that contract, standard contract from 2008, but I was a participant in the program in 2009. And these contracts from 2010 are proving that. There have been two contracts. One that somehow shows the intention of Basconslux and my relation to Basconslux under the program. And the second one is a contract that Basconslux decided it would be more viable for them. To me, it did not matter what contract which of these contracts to sign. For me, it was important to have a property in Ciocana because it was already built. It wasn't better for me to wait for 6-7 years until the building on Melestiu Street. But my participation under the program was in relation to that complex on Melestiu. And I studied this document and I saw that the commission asked the city hall and asked the Court of Accounts for information about the land plot on Mircea cel Bătrân, while the legal relation or what the commission invokes to me about the preferential price program relates to the land plot on Melestiu Street. The commission did not ask for that information. That change of location led to a change in contract of land plot of apartments.
Okay, yeah.
It wasn't something that would be beyond the limits of a program in 2009.
So are
the
you
apartment and the contract.
Yeah, go ahead, finish off. Yeah, go ahead, sorry.
The contract of 2008 had effect for the program in 2009 because in 2008 a program for prosecutors to access preferential price housing did not exist. Such a program did not exist for prosecutors in 2008. No program for prosecutors in 2008. It started in 2009. The exchange of location allowed me the possibility to move to another real estate that is on another address with a different contract. But in the meanwhile, we signed contract 172 of 25th November 2010 and the annex to it. And the payment order was also done on November 25th of 2010. Maybe that's why Basconslux chose to have these contracts separated from one building to another building, because one is on Ciocana with the one that is located in the center. And probably they are the ones who registered with the cadastral office or notary, I don't remember now. Or was it? No, actually it was me who registered with the cadastre that contract. So what I received, that's what I went and registered. But the contract had effect on the program of 2009.
Okay, but are you saying that the contract of 2008 actually relates to a different building or a different apartment than the contracts of December 2010? And if so, what is then the...
Exactly.
And if so, then what happened to the implementation of the 2008 contract? Was it simply ignored, or normally, certainly with construction companies, once you sign a contract, you're bound by it and you better implement it. So what happened with that 2008 contract? Was it simply ignored? Yeah.
That was the contract that was executed because the building in 2010 was already finished, and we signed a contract for a finished construction, for a construction that was the final stage. It was not put into operation yet, no final reception act, but it was almost finished, like a couple of months left before it was put into operation.
I hope you understood, or maybe you'd like me to clarify it further.
Yeah, maybe Nadezhda, if you have a follow-up. I must say I'm a bit lost as to what the purpose of the 2008 and the 2010 contract is, but Nadezhda and then Victoria, please go ahead, and then we will continue. Yeah, Nadezhda, you first.
Domnule Codreanu, bună ziua.
Mr. Codreanu, greetings. I just wanted to make certain that I got things right. So, throughout the entire evaluation process, in the initial evaluation and now, we have a contract that you do have right there in front of you. The date says 15th of May 2008. That is correct. Is it true that as regards this contract, on that contract, there's also a stamp that it has been registered with the cadastre in December 2010, and the takeover document report of 2010. Now, it is for the first time now that you tell us that this contract, although the date is the 15th of May 2008, it had never been signed by you, that you haven't seen it. You first saw it in December 2010. Is that correct? Yes. Yes, yes. So when you received it, it was like a standard contract that you signed without paying attention to the date. Exactly. To me too, that was an enigma, an unclarity that I tried to get my head around, and I tried to explain it to the Commission as well. How could I have signed a contract in 2008 if the program started in 2009? So it didn't make sense. There is no, it's not rational like that. And then I understood that the contract, in principle, I signed it in 2010 when I paid the money in November. And then in December, I registered it with the cadastre because it's the same period, November, December 2010. That's when it was signed, and that when it was concluded and paid for and certified by a notary and then registered with the cadastre. So all of this happened in November, December 2010. So you, just to clarify this, you participated in the program that was managed by the General Prosecutor's Office, that was launched in 2009, and you were supposed to be given an apartment on Melestiu Street. That's right. However, after you were granted this right, you negotiated directly with the company to make this exchange, or was it via the office? I went to the General Prosecutor's Office because all that correspondence would go through the commission of the Prosecutor General's Office. So we didn't have a direct communication with Vasconcelos. And they said that there is such a possibility. And I did that only because I found out that other colleagues of mine have also done it. So before me, other colleagues also did it the same way. And I thought that that would be an advantageous transaction because the location was next to my parents and because the apartment was already finished in 2010. The apartments had already been built and ready.
Herman.
Victoria, you have a question. Go ahead.
Yeah. Yes, just to clarify the timing of this, and I understand that you entered into some agreement with Vasconcelos to purchase an apartment that was not yet built in 2008, and that was not a part of the prosecutor's program, correct?
Yes.
Okay. Right.
Yes, that was, and that was like a property of Vasconcelos, I guess. That land, I mean, and the block of flats in Ciocana or Mircea cel Bătrân Street, in other words.
Okay, and did you apply to the Prosecutor General's office to participate in a program for prosecutors to purchase preferential housing, the one on Milestru Street, in 2009 when the program was established?
Yes. Yes, exactly.
And at this time, you were already in contract with Vasconcelos to purchase another apartment, correct?
No, I mean, that is where the big error is. I didn't know at the time, I wasn't aware of Vasconcelos. I didn't have any tangencies whatsoever with the apartment on Mircea cel Băstrân Street in Ciocana district. I did not have anything to do with it. I just exchanged ownership, so to speak. Like I don't know how to put it. My apartment from Melistiu, I gave them the apartment on Melistiu. They gave me an apartment from Ciocana, which was already finished. On Melistiu Street, there was just a land plot without anything built on it. There was only an intention to build something. And they accepted this swap because the center location was much better, much more advantageous, and a much more advantageous price compared to the location in Ciocana city district, because the apartments in the center, unavoidably, they're more expensive than apartments in other city districts or the outskirts. And Vasconcelos was happy to accept the swap.
But that also,
and I didn't have a problem with the commission. Ask again, please.
Victoria, can you repeat?
The Prosecutor General's office was involved in that arrangement, and it was done as part of that program, correct?
I am certain that yes, because we couldn't have done anything at all without the Prosecutor General's knowledge. I think yes. Well, this happened 13 years ago, but so I guess yes, because it couldn't have been possible for the Office of the Prosecutors General to not know. They would have told me. They would have told me, hey, you should pay for this, for that apartment on Melistiu in installments, because the apartment on Melistiu Street has been paid by prosecutors within for 5 years in different installments, and the Prosecutor General would have asked me, why aren't you paying your installments, Mr. Prosecutor? They knew that I paid for the contract in one single payment, one single lump sum was paid for the contract. They knew I didn't have those installments whatsoever. That I never had anything else to do with the commissioner, Vasconcelos, or anyone else. I took the contract they gave me that was signed off by the administrator of the company. I took it to the territorial cadastral office. I registered it, and that was all.
Okay, so just to understand, the document that is dated in 2008 with Vasconcelos, are you saying that you didn't sign that document in 2008?
Yes, I did not sign it in 2008. I couldn't have signed it in 2008. It was not signed in 2008.
So,
it was signed in 2010, in November 2010. It's when the money was paid, 25th of November 2010, or 2 or 3 days difference. So that might be a difference of 2-3 days only.
Okay, and that is the agreement to purchase the property, changing the location to Ciocanu, correct?
Yes.
Okay. Right. And the property in Ciocanu was also purchased at a preferential price, correct?
No. No, I said this in the previous hearing. That again leads to an issue. At the time, I wasn't married. The commission that was established under the Prosecutor General's office, they refused to give me an apartment larger than 50 square meters, because the unmarried ones would have less than 50 square meters, and those who had a family, 60 to 70 square meters apartments, depending on the number of the members. And then, since the location was changed, in the Ciocana block of apartments, Vasconcelos didn't have an apartment that was 50 square meters that I should have been given according to the decision of the commission established at the Prosecutor General's office. And it told me we have 67 square meters apartment. The smallest size is that. So if you want it, we can give that to you. However, this difference of price, those 17 or 18 additional square meters, you have to pay for this at the market value, the market price for that. So I accepted that agreement. I accepted that condition that Vasconcelos tabled. And I paid for the 17 square meters. I paid 600 or 650 euros per square meter. The preferential price was about 350, 370 euros per square meter. So 17 square meters were paid for at the market value.
Okay.
50 square meters, I paid for that at the preferential price that was true for all the prosecutors who used that program.
Okay.
I think I explained this in the previous interview, in the previous hearing as well.
But then if my question is, so you are saying that the contract of 15 May 2008 was not signed by you. But if it was not signed, what was there to swap in 2010 after you participated in the program of the preferential housing?
Nu, el a fost semnat de mine
No, I signed the one in 2008. The contract in 2008 was signed by me. It is only that it was signed in 2010, in November 2010, when this contract too was
signed. The date of
signed.
2008 on the document, if it was signed in November 2010, why wasn't the date changed? It's not that complicated.
Eu nu înțeleg din...
I don't know what is the reason why Vasconcelos gave me that 2008 contract. I told you what my position was and my explanation. The explanation that I think was what I think happened. I wasn't in touch with the Vasconcelos. I didn't talk to them after the contract was done, but I think that the 2008 contract, that might have been like a standard, like a template contract valid only for the assets in Ciocana, which was for everyone, regardless if you were a prosecutor, anyone, absolutely any person who wanted to invest in an apartment in Ciocana, they could enter into such an agreement in 2008. I guess in 2008, they were just initiating the construction of the block of apartments. That's the only way to explain it. I guess they had this standard templates or contracts for every separate block of flats. And not to make a mess or confuse themselves with the different contracts for the different blocks. I guess they just gave me that contract on which the date was 2008. But in the meantime, we've also entered into that other contract when the final reception happened, when the money was paid. I was given then the contract dated 2010, the 2010 contract. It also has a stamp, the signature of the administrator. My data is there. Everything is there as it should be in a contract with all the terms and everything that shows that I was a participant in this program since 2009. That was launched in 2009, that is. So it is in 2010 that I actually signed the contract. So the reason why are the two contracts, one is 2010 and one is 2008. As to that question, it's perhaps that's what there was the possibility. There was a variant proposed by Vasconcelos. There was nothing that has to make changes or amendments to the essence of the contract. It's the same square meters, the same people, the same money paid, and this was confirmed by a payment order of 2010, as I already said.
Okay, let's move on.
Excuse me.
Okay, but please be brief on the specific questions that we have. So please go ahead.
Well, that was Madam Tatiana who wanted to take the floor.
Oh, sorry, yeah, Tatiana, go ahead. Yeah.
I don't understand. You are a prosecutor. How do you sign in the year 2010? How do you sign a contract that has the date 2008? Didn't you read the contract? Didn't you look at it? I just can't make sense of it. I don't remember what has been happening, what events that were taking place. We're not talking about events. It's just when you sign a contract, the first thing you look at is the date, the month, the day specifically, the year, the month, the day. How could you have signed it without having paid attention to the specific date? I signed it perhaps because they insisted on it. I was not the one to put together the contract to write it. What do you mean they insisted? You said in 2010 you signed on a contract that said 2008. How can that even happen? I don't see a problem about it as long as their interest was observed. I mean, the interest of Vasconcelos. My interest was observed as well. I did not encroach upon other people's interests. They proposed that contract to me. They put it in front of me. If I said no, I wouldn't have been able to use that program. But I guess this 2008 contract was one like to express intention that was concluded before the contract of November 2010. And then I paid for it. And then I have a 2010 agreement as well that I entered into.
Okay.
Where is the illegality in my steps? And what is the incorrect thing that I did?
let's move on to the next aspect of this discussion. So we and you also touched upon that in your further explanations. So in 2013, you signed a sale purchase contract with, as you mentioned yourself, with your sister, by which you officially sold the apartment for 408,671 lei. But in your annual declaration for the year 2013, you indicated that you received 0 lei income from the alienation of this immovable property. The question is, how can you explain that on the one hand, you signed a sale purchase contract for a specific price that is never paid? You also mentioned that, but why would you then sign a sale purchase contract? Wouldn't it have been easier then to donate that apartment to your sister rather than signing a contract that actually does not present the reality? Can you explain that?
I've explained it in the previous hearing as well. At that time, we went to a notary, and I asked the notary, what is the best thing for us to do without violating the rules, certainly. And the notary said that it's not a problem for you to have a sales and purchase agreement, given that it's siblings and there couldn't be any claims between the parties further on. And I didn't even have a doubt that about 13 years later, or 10 years later, this would be 10 years later, this would be raised by the Privacy Commission. It's just a procedure that took place at the notary.
But at the time
did
when
not
you,
have.
at the time when you signed the sale purchase contract with your sister, at that time you already knew that there would be no transfer of funds between your sister and you yourself.
Well, it didn't make sense because the money was mine and my sister's and my parents. There was no transfer to happen. It was also our money, the money of our family. How can I explain it in a way that I am understood? I explained it in a number of times. The apartment was paid with money of us all, mother, father, sister, I. When the contract of sale and purchase was concluded, that I, well, called it as such fictively, and that didn't have negative effects for other people, we didn't raise an issue around taking money from my sister and somehow also like it was also at the end of the day the money of our family, so it was within the family, and it was not bought from some other people's money to return that, as in having the sister pay that amount and to sort of have to pay that somebody else. No, the money was initially, the money came from, I mean, it was the money of the family, and my sister was part of the family as well. How could I have taken another amount, another sum of money from my sister if it was also her money and our family's money? And
Okay.
actually, I don't know.
Thank you very much. Now, my next question then is, at the initial hearing, you referred to Article 10, 1089 and 1090 of the Civil Code, which we established only came into force a number of years after you signed the contract. In your further explanations today, you referred to, what is it, I think, to Article 221 of the Civil Code applicable at that time. But from what you read out, and of course the commission will further study in its deliberations and decision making, also there I hear the words nullity and void for contracts that are fictitious or simulated. Are you saying that this was a fictitious or simulated legal act? And if not, why not?
Well, this notion, this term, well, these are identical terms, but it's just when the law was applicable, it was like a transaction, like a simulated convention agreement, and the law provided, like in 2013, when this contract was signed, well, same as now, that simulated contracts produce effects as long as they are not harmful to third parties. So that's from a legal point of view. That was a contract that, well, there was no intention, actual tension of sale and purchase, but alienation, in other words, was alienated to my sister, and this contract continues to be valid. Nobody challenged it. There can't be challenges as regards this contract, and the law provides for the possibility to have for the possibility of existence of such a contract. The law doesn't provide that such contracts are illegal. They are illegal only when other parties, legal entities or individuals are prejudiced in some way, if they are injured in any way, regardless of the situation, if there's a harmful effect for them. This was a family matter. We've addressed it in our family, and in its decision, the Supreme Court of Justice was clear about it. It said that there is no doubt as regards this matter, because family and family members, as per the law and as per our national tradition, family members help one another, and they can help one another. And I did not act
Mr.
with
Codreanu,
intent
sorry.
of fraud against my sister. Then what is the problem? There is a contract
Mr.
provided by the law
Codreanu,
221.
that is all fine. For me, it's about the legal questions, not about the assistance of family members, which I think we all very clearly understand. It is about the legal concept. So are you saying that the civil code, the provisions which were applicable at that time, that the question whether or not a legal act was null or void depended on whether there would be harm for third parties? Is that a precondition for this provision to be applicable?
Da, stimați membri ai comisiei.
Yes, the honorable members of the commission, and this matter in your request on page 3, this came up as well, where the commission has put down, well, has referred to this legal provision, Article 221, and if necessary, I can read it out
No,
aloud
it
as
doesn't.
well.
We can, after our meeting, of course, the commission will also study it ourselves. I just wanted to make sure that you consider that to be a precondition for the application for that provision. Of course, we will study that later. I think are there any members of the commission that have any further questions about this particular issue? If that is not the case, I would like to move on to the second issue, the method of acquiring a 49.1 square meter apartment and surface-based housing and the privatization of that house. Sorry?
Domnul Hibă, mă scuzați că vă întrerup. Eu aș considera
Apologies for cutting you off. I think it would be reasonable, since the commission accepted to hear the witness. Can that witness be heard before we move on to the second issue? Because those testimonies have to do with the issue we've been just talking about. And perhaps that witness could shed more light and bring more clarity for the members of the commission, so that we don't go into the second issue, then back to the first one. Sorry for interrupting, but I think it would be reasonable, and it would be essentially important to hear the witness now before we move on to the second issue, so as to make sure that we got to the bottom of the first one before we move to the next one. And apologies again for having interrupted you. And in addition to that,
I think
as far as I know,
your point is clear, Mr. Codreanu. Then let's do so. I think we have to. There are some technical issues, so we have to wait for a few minutes, and then we will. So our staff will now assist with setting up the arrangements for the person you asked to be heard, and then we interrupt until he is ready, and then we will go on with the
să nu facem să aștepte, deoarece poate durează un
I wouldn't want that person to have to wait too long, because that person has been around here since
I think the point
4
is clear.
o'clock. And
Vă mulțumesc foarte mult.
thank you.
I think we're now waiting for, yeah, okay, very good. Now we are complete again, and I would like to welcome Mr. Andrei Pashkar, a person to address, and that is the official status, and a person to address an issue about which the Commission has indicated it has serious doubts. Welcome, Mr. Pashkar. I will explain the procedure and the introduction first, and then we have a number of questions for you. As you may know, the candidate also present this afternoon, Mr. Vitalie Codreanu, has requested the Commission to hear you in relation to an issue in the resumed evaluation of the candidate, Mr. Codreanu, on which the Commission has formulated its serious doubt. The candidate provided explanations on why he requested you to be heard, as you, according to the information provided by the candidate, have acted as the secretary of a commission established by order number 130/36 of the General Prosecutor of 22 December 2009. And that dealt with the implementation of a program of preferential housing for the prosecutors and employees working at prosecutors' offices in Chisinau. The Commission has accepted the request by the candidate, and thereby we have the hearing with you this afternoon. I will first read out to you the serious doubts as the Commission has formulated in relation to Mr. Codreanu, and will then proceed with asking you a number of questions. So the serious doubts that we have formulated reads as follows, and I quote, "The Commission has serious doubts about the financial and ethical integrity of the candidate in that he made use of a preferential housing program for prosecutors in order to allow his parents to buy an apartment for his sister at a lower than market price, despite the fact that the candidate's sister was not eligible to participate in the program. Serious doubts also exist in relation to the fact that the candidate never informed the Prosecutor General's office that his participation in the preferential housing program was not to improve his own housing situation, but to improve or to benefit his sister. Serious doubts also exist that the candidate did not meet the eligibility criteria of improvement of living conditions, personal investment in the construction of an apartment, and full transparency in participation in the program, and thereby used public funds aimed at improving living conditions for prosecutors to benefit his sister in buying an apartment against the lower than market price. In addition, serious doubts exist relating to the sale of the apartment to his sister in 2013, as there is no proof that any transfer of funds took place in relation to the sale of the apartment, contrary to the candidate's representation in the sale purchase agreement. The Commission submitted the statement of facts and these serious doubts to the candidate, and we received a written response by the candidate to that. Today, prior to you zooming into our meeting, the Commission has listened to additional explanations by the candidate and has asked the candidate some questions about this issue. We now have a number of questions for you. We will first get started with those questions. I will start with those questions, and other members may have questions as well. Once we have finished, also Mr. Codreanu, of course, has the opportunity to ask you any further questions. My first question is the following. On 22 December 2009, the General Prosecutor issued order number 130/36, by which a commission of 9 members was established. 8 of the 9 persons were prosecutors. The 9th was a construction expert. Is that information for the Commission? Is that correct?
Bună ziua tuturor!
Hello, everyone. Can you hear me?
Yeah, we can. Absolutely. Yeah.
I am Andrei Pascar, and with respect to your question, I would like to inform you the following. Indeed, in 2009, on 22nd November, by the order of a Prosecutor General, a commission was established, a departmental or internal commission of a prosecutor's office, where 8 members were prosecutors and 1 was a construction specialist. Indeed, I confirm this information. If I may, I could continue my idea and tell you that in a very brief period of time after all technical tasks of this commission were fulfilled, 2 changes happened. 2 members were replaced. And in the commission, only prosecutors were members afterwards. So the technical staff was excluded because he fulfilled his tasks of a purpose for which he was part there. So the commission acted until the end, consisting only of prosecutors.
Okay, thank you. I would suggest that we first go through a list of questions that we have. If you feel at the end of that list that you would have other information that you think would be relevant, then of course, please proceed. But let's first go through the list of questions that we have for you. And what can you briefly explain what your role was in this commission? Was that indeed to be the secretary of that commission, or did you have another role here?
I was the secretary of the commission, and I was handling with ensuring the activity of that commission, including a number of documents, of organizational matters, and summoning the meetings of the commission when needed.
Okay, thank you. And during which period did you execute this role? Was that from the beginning in November or December 2009 until what time was that?
This commission worked starting with 22nd November 2009 until the housing complex for prosecutors was put into operation on 26 Melestiu Street.
And when was that?
If I'm not mistaken, it was somewhere around 2017.
Okay. And all the time during the entire period of the existence of that commission, you were the secretary of that commission.
I confirm that.
Okay, thank you very much.
The entire activity.
Yeah. And the mandate of the commission, as we understand it, was required to ensure the distribution of apartments amongst prosecutors who would be eligible to participate. Is that correct?
One of the competences of the commission, because the commission had several competences and tasks.
What were the other competences of the commission?
Organizational, supervision, or control of the construction, organizing the process of preparing the documentation before the construction work started and subsequently during the time. So looking into the construction works of that building until it was put into operation.
Okay, thank you. And according to the order, or in the order, a number of criteria were included for the eligibility of people to participate. And so the commission had to check the list of people, so that is prosecutors working in prosecutors' offices in Chisinau. And as we see, there are three preconditions over here. The first one is the need of improvement of living conditions. The second one is that prosecutors are eligible if they want to participate in the construction of the housing complex through their own investment. And the third criterion is that they would respect the principle of transparency. Are these the correct criteria applied?
Yes.
Okay. And were there any other criteria applied by the commission in the distribution of apartments, or were these the only three criteria?
These were the principal, the core criteria. Subsequently, other criteria were also identified and applied with respect to identifying or providing prosecutors and their family members with housing, improvement of living conditions for prosecutors' families.
And were those other criteria, were they put on paper at some point? I suppose so.
They were deduced from previous activities of a prosecutor's office, of activity of commissions or other working tools of the prosecutor's office relating to providing housing space. I mean, moving from one value system to another, we also needed some reform of the rules for providing prosecutors with housing space from the old housing code to the new rules, so through the old rules and up to the amendment of lists of people who are waiting in a queue, in a line for an improvement of housing conditions. We had such situations.
Okay. And when were those criteria changed? At what period? When was that in terms of time? Was that soon thereafter, or was that a number of years later?
The activity of the commission, as I said before, took some time between 2009 and until 2017. And during the activity of the commission, some criteria were identified as new criteria and applied. So they were not identified from the very beginning. From the very beginning, you were right. We had the three criteria. Then others were added. Criteria, conditions, and situations that were applied as a result of identifying or as a result of changes in situations.
And when Mr. Codreanu was applying for the participation, I think he was one of the first ones in that whole program at the end of 2009. So at the time when he applied, those original three criteria were the only one that were applicable. Is that correct?
I can't say because I don't remember when Mr. Codreanu applied, under what circumstances and what he wrote in his application. That was a procedure that was unique and equal for all prosecutors. They were filing an application to get allocated or to benefit of participating with own money for the construction of housing space if they had none, or for the improvement of living conditions, also from their own resources, money, in case if at the time of applying they needed improvement of living.
Yeah. Okay. And how did the Commission exercise control over these applications and assess whether prosecutors who applied and wanted to participate in the program, whether they all met those 3 criteria? How did that Commission control that?
Every person that wanted to benefit of this housing through this mortgage process, or to benefit of improvement of living conditions through the same method, on their own account were filing an application and attached a number of confirmation documents that were proving their need, whether they have or don't have housing, whether they own or don't own the necessary housing space as needed per family member. So depending on the criteria established in the housing code at that time. And one of the criteria was obviously the family status, a certificate. So it's a certificate about the membership of a family, any dependents, children, parents, people with disabilities, and so on. So this was one thing that everyone individually was formulating in free form and was taking responsibility for the accuracy of data there, because all data were subsequently checked.
Okay.
Depending on
Yeah, go ahead. Yeah.
depending on the competence or the way the Commission could actually check that.
Yeah. And how then did the Commission decide upon these applications? So the Commission checked all the information that was provided by the prosecutors?
Yes. In all meetings that were organized by the Commission, we were discussing and examining candidates, the candidacy of the prosecutors or family members who needed this allocation of housing or to benefit of this housing, or who needed an improvement. So the documents that they have submitted. And some or most applications or documents were checked by the Commission by means of various methods.
And what were these methods?
Methods of verification and control, direct and indirect. Making requests to the appropriate authorities that were keeping records of the living conditions, availability of this housing space, real estate. We worked quite a lot at that time. These were not householders associations, but there were some rudimentary bodies that were managing the housing stock. And there were also documents that existed with respect to the previous allocation of service housing or benefiting of programs that existed before, either state programs or local public authority programs, depending on.
Okay. And do you have a copy of the application by Mr. Codreanu at that time? And if not, can you recall what he included in his application?
au fost depuse
There
undeva
have been filed around
peste 250 la proiect.
more than 250 applications to this project. Whether they were kept or not, I don't know. I did not have a task to keep them
Sistematiza
or to systematize them.
erau, adică
I know that
cele
they
care
were there. So
spun erau standard scrise sau
the applications were in a standard phrasing, like I, prosecutor in that office or in that body,
dispunând de familie sau dispunând
having a
de
family or
întreținere atâtea persoane,
having so many dependents,
spațiu locativ,
or not having on housing, I asked to be included in the list of prosecutors that will benefit of
spațiu locativ prin metoda
housing through mortgage.
independență de numărul
And
de
depending on the number of requested rooms, they were attaching documents. At that time, the prosecutor's office was going through
exod. Deci
a big
asta era
exodus
la
that was
Institutul Național al Justiției
before the National Institute of Justice, before the prosecutors started to be hired through the National Institute of Justice. And there were many young prosecutors who needed
locativ. Deci
housing.
de generații în procuratură și venise foarte
They were the
tineri care aveau nevoie de
a generation of young prosecutors, and they needed to be provided with housing. And from what I remember, there were
erau în rând preferențial cei care nu
several lines in a way. Like there was a preferential line, like the ones who had no housing and had a family. Second preferential line was the ones who needed improvement of living space, and the third line was the ones for people who
puteau să mai aștepte. Adică
could
persoane care
wait.
erau, de exemplu,
People who were not, for instance, married, had no children, and so on, like young employees.
marc o chestie.
I would like to make one remark.
Mhm.
Providing with housing, in that case, was only for prosecutors working in Chișinău municipality.
Yeah. Okay. And so was Mr. Codreanu and were all prosecutors required then to provide? Oh, okay. Can you hear me? I think the line was
Da,
interrupted.
eu vă aud.
Yes, I can hear you.
Okay, very good. Then we will continue with our discussion. So when a prosecutor applied for the program, that prosecutor and this therefore also Mr. Codreanu was required to provide information about the housing situation that he had at that time, so his family condition and the size of the apartment, etc. Was that required for him to do so?
Să vă spun cum sau era
To
procedura.
tell you, well, the procedure was general.
Ea reprezenta în felul următor. Dacă
It was the following. If someone
includerea
asked
în listă
to be included in the list,
compartiment pentru îmbunătățire, pentru
either for
obținere,
improvement of housing or to obtain housing or for other
sub propria
aspects, he or she on his own responsibility submitted documents confirming that. I cannot say what Mr. Codreanu submitted or what he did not submit, but I believe that with respect to him, the same criteria were applied as to all prosecutors.
Okay. And then if the and you mentioned that, but I just want to have it confirmed again. Did the program allow for the assignment of housing to persons who were not a prosecutor or who were not working in a prosecutor's office? Or was the fact that someone was a prosecutor an absolute precondition for the participation?
Participare în program.
Haideți să fiu, dar atunci mai explicit. Deci,
Let me
unul
be
la-
more clear. First of all, the program was developed and applied only for prosecutors
și membrii familiilor lor,
and
nu
their
necesar
family
procurori
members,
fără familii sau
because
fără
we
membri
can't
din familie.
imagine
Sau
prosecutors
procurori
without their
care
family members
aveau nevoie
or
de
young
spațiu
prosecutors
locativ.
who, as I said, needed housing. Secondly,
Da?
this
De
program
fapt, a
actually
reprezentat
represented
inițiativă
an
venită din
initiative
interiorul
that
însăși
came from
procuraturii,
inside
deoarece
of the prosecutor's
numai
office
era
because
posibil ca
it
organele
wasn't possible
administrației
for
publice
local
locale
public
să
administration
facă
to
prin spații locative
provide
și locale de alocare
housing space that belong to the local authority to give them to prosecutors.
să stins camera.
And the camera is off.
Yeah, I see the camera is off, but we can still hear you. So let's continue with
Da,
our.
în regulă, în regulă. Da, desigur. Da.
Yes, let's continue.
Yeah, okay. Thank you very much for your flexibility. But if Mr. Codreanu applied for the program and would have clearly indicated to your commission that the application would relate to providing for housing for a family member of which would then not be part of the family anymore, would he have been eligible for that program? Because in the end, then the program would be for the family member. The housing would be for the family member and not for Mr. Codreanu himself. Would he have been eligible for that?
Vreau să încerc să vă răspund, dar
I want to try to understand and to make myself understood
de facto
how actually
a fost gândit acest program și unde s-a
how what
ajuns.
was this program design of thought and
Pentru
where did we get?
membrii
It was meant for
familiilor lor
prosecutors and their family members who needed improvement on their living space. The members of the family
o expunere sau este un înțeles
that is a
general. Deci,
general
în cazul
notion.
acesta,
In this
de
case,
la caz la caz,
depending on a case, from a case to another, it was being checked as possible whether the information provided was correct or not, if the family members are listed correctly or not.
organele
So the
competente,
competent bodies,
specializate,
the specialist
eliberau
bodies,
certificate
were issuing certificates that
conțineau informații
included information about the family
de
members.
independență. Copii minori,
Again, for instance,
părinți
minor
sau
child,
aflați
parents,
în îngrijirea acestora sau la întreținere.
dependents.
Pare mi să actele astea erau eliberate
I think
numai
these
de,
documents were issued by
asociațiile de locatari
these
sau de,
householders
călători
associations,
de
or
și informațiile erau furnizate
and the
de
information was provided by
APLP.
them,
Mai
by
mult ca
this,
atât,
he says AFLP.
cât nu pare de bizar,
No matter how bizarre it sounds, but in some cases, the Commission accepted to include prosecutors in the list of people that needed improvement of living conditions
pentru un apartament mai mare,
and for a larger apartment. I think based on certificates that were asked for and submitted about the pregnancy of the prosecutor's wife, for instance. Obviously, that this program that lasted from 2009 to 2017, like for 5-6 years, in many cases, prosecutors changed their family status. Children were born, parents died, well, new dependents happened, or dependents did not exist anymore. So in some cases, we also took into account those certificates that, for instance, the wife is in its 8th month of pregnancy or in the 4th month of pregnancy. These certificates, as they were information with private data, under the reserve of their accuracy, were provided by doctors who, for instance, well, with whom the pregnant woman was registered, for instance. From what I remember, when it could be influenced for a person to get a larger apartment, like by square footage or have more rooms. So if you understand what I mean.
Yeah.
What Mr. Codreanu presented at that time, was he married? Did he have a family? Who were his family members? I can't say. But certainly, I said that subsequently we found that the purpose followed by this commission, or by this program, to put it better, was, well, went way beyond that. For instance, children of prosecutors benefited of apartments, of prosecutors who were working then. Maybe during those 6 years, they got retired and they couldn't work anymore, but the apartments were transferred to family members, to relatives of first or second kinship degree. Others concess their right to other people. And I would like to mention the following. Let's make a difference. We did not allocate housing space. We established, or we allowed prosecutors to take part in a program, institutional program. Can you hear me?
Yeah, yeah, absolutely. Yeah, we're listening carefully. Yeah, we can hear you very well. Yeah.
Something changed here, that's why.
Okay.
Well,
Yeah.
so
But please go ahead.
So it was an institutional program that they could benefit of the right to obtain subsequently through an investment, a real estate that was an apartment. So for these apartments, or for the construction of these apartments, no funds were allocated from the state, no funds from local public authority, of other entities. Only money paid in installments, financial resources of the beneficiaries, or of beneficiaries to be, of prosecutors or their family members.
Yeah. There is just a brief interruption, because we can hear you, but we don't see you. I don't know whether you're able to see us, but there is a suggestion to briefly reconnect you to the system so that hopefully we can also see you again. So I would suggest that we interrupt for 1 or 2 minutes and have the experts. By talking, it already works. Miracles happen. That is good to see. Good to see you back. And then my question was that when you were talking about family, so when a prosecutor applied for participation in the program, family, was that normally considered as the prosecutor and his or her children or future children, or was it also relating to other members of the family?
Look, I can say with certainty only one thing. In our view, what a family means, a family represents a cell of the society, and the members of it are people related by kinship, children, parents, spouses, the parents of one of the family members of the spouse, for instance, or depending on the peculiarities of a situation. For instance, in certain cases, the Commission rejected to allow them to use this right to well, rejected some from being part of this program, and this was rejected to some prosecutors who were they and their families, that is the parents, the wife's parents, his parents, they all, for instance, had places to live, not apartments merely, but for instance, detached houses. The apartment they were living in was in the name of the apologies parents. The house where the parents lived, they were registered officially there. And in instances like this, considering the sizes of the housing space, some of them actually had a surplus, quite big a surplus in terms of square meters. And in the view of the Commission, they didn't require improvements. So they didn't need even to be given an apartment altogether, not to mention improvements to their living space they already had. So one or two prosecutors had their applications rejected because we looked into it and it was established that him, his wife, the parents of the wife, and the children already have enough living space. There are houses and apartments and vacation houses and what's not. Well, was different from case to case.
Okay, thank you very much. But in when deciding upon the assignment of a particular apartment or housing facility, was it always the assumption that the prosecutor, him or herself, would also be going to live in that apartment?
Mă scuzați, sunt nevoit să concretizez întrebarea.
Apologies, I think I have to make sure that I understand the question. In what apartment? You mean
So
that if the prosecutor, are you asking if the prosecutor was buying the apartment or was getting the apartment for themselves?
Yeah, my question is the following. Maybe I did not express myself clearly enough. If a prosecutor applies, then the commission would look whether also, or would see it as a precondition that the prosecutor, him or herself, would also actually go and live in that apartment that will be assigned. Is was that always the understanding of the commission?
Știți, cred că asta a fost undeva o...
You know, I think this is something that we perhaps overlooked. We didn't impose such conditions on anyone. We didn't have such a condition. And one more thing is that I keep hearing for the second or third time already today, this way of saying as preferential price. Well, if I may try to be explicit enough when it comes to this. So what is preferential price about? There is a distinction, as far as I understand. There's a distinction between the market price and the price that is the cost of the apartment meant for prosecutors. In this regard, I must make a clarification, because these apartments, they only apparently were at a preferential price. But why did we have to implement programs like this? Why did we have to establish a commission for this and to identify possibilities for one to be part of such a program? It is that the buildings the blocks of flats were built by a construction company and given us at the actual cost, like the prime cost of a square meter. And that price at that time was 300 euros for a square meter, if I'm not mistaken. And back time, we had a 340 euros for square meter. So there were some costs associated with access ways. So there's some costs associated to make it to building such an access way. It was not provided for in the initial blueprint. And there was something else to provide some utilities. There was something else that we added, and there was like 50 more euros were added to cover for that, as far as I can remember. But I can't say that it was a preferential price. We were party to the contract, and we provided the land, and the construction company provided the services. They did the construction works. Initially, as members of the commission, we also organized a tender. We made public our intention for a building to be built, and we received a number of offers, a number of bids from several construction companies, and we chose the one that we thought was the most convenient. And that's why we needed a construction specialist at that time, because that person looked into everything was in line. We had other offers as well, where the price per square meter was even smaller, but they were not realistic as we figured it out. That construction company couldn't, in the view of the specialist in our team, the company wouldn't have been able to actually see that project to the end. So that's why we had a project of 340 euros per square meters. There was quite a competition in this regard. And this was one of the tasks of the commission, to also find that company that would build an apartment, a block of apartments for an adequate price housing for prosecutors. So that's with regards to the preferential price. As regards, though, the other matter that you addressed, I think the question perhaps should be reworded, or maybe to figure it out again. I really didn't understand what you meant. If you could please maybe reword it in another way.
Yeah.
I would like to provide an answer, but I want to make sure that I understand the essence of the question.
Okay, let me try again, and thanks for your clarification, the preferential housing aspect. My question is the following: if a prosecutor were to apply for participation in the program, would it be allowed that that apartment to be assigned to the prosecutor would not be used by the prosecutor, him or herself, but only by another family member, without the prosecutor himself being part of that project?
Now I understood the question. We never established such a condition. We never imposed a condition like this on anyone. As a commission, in our project, so to speak, we pursued making available living space for prosecutors and their families. But can you imagine that the whole building process took 6 years? Over 6 years, there were so many changes in terms of all sorts of terms and clauses and conditions and whatnot. The family status. The commission established 6 years later that many of those apartments, that the right to such apartments were often transferred or ceded to family members, sometimes even to other people outside the family. maybe that's something that the Commission overlooked, but we did not impose conditions like this, that prosecutors, for instance, will have the right to obtain using their own money to obtain a property in which to live, as in was not imposed to necessarily be them living there, not their family members. So I want you to underscore that we focused on housing space for prosecutors and their family members. And over the years, it turned out that it is quite interpretative, as in who are the family members and who, at the end of the day, can be the one actually, well, using the apartment. And I think that, well, this is my answer to your question.
Okay, no, thanks very much for that clarification. So in principle, it could mean that although the program was meant to improve the living conditions of a prosecutor, that an apartment would be assigned to people not including that prosecutor, and thereby not improving the living conditions of that particular prosecutor. That is the consequence of your answer, isn't it?
Da, da. Deci noi am
Yes,
constatat
yes.
Okay.
We established that apartments were then in the hands of other people. It could be family members, direct or indirect family members, or even outside of the family too. But that wasn't,
ulterior.
and well, turned out to be the case later, as we found out.
Okay. Was it also required when the prosecutor applied for the program that he or she would have to inform whether he or she was involved in another program? For example, when if a prosecutor would also apply for service housing, would that be a reason not to grant participation in this program?
Nu ne-am ciocnit, sau mai bine zis, nu ne-am
We
pus
didn't come across, or rather, we didn't have this question in mind. Because, for instance, a more experienced prosecutor, if they were provided at some point in time, like in the beginning of their career, if they were given some service housing, for instance, at that time, they could have had a wife and a child, and they, if the LPA gave them, according to the law prosecutors, like an apartment, but then say, for instance, the situation changed, like the family became larger, like more members joined, more children maybe, then that prosecutor would anyway need improvement of living conditions. And that was the goal, actually, to provide housing space to those who didn't have one, and to also ensure an enlargement, or in other words, an improvement of living conditions. There are prosecutors, or there would be prosecutors who had a child, two or three of different genders, and they needed space to live in as per the law that was larger and to have more rooms. And all of these aspects were taken into account. But to impose a condition as such, we didn't do it, or we didn't pay that much attention to this. What is more, I must tell you that the Commission has worked in such a way, or it was possible by this method, like by mortgages and by investments, that is, it was possible for this right to be granted, by the way, to more than 240 prosecutors and family members of prosecutors. And at a moment in time, we realized that there were 10 apartments more. There were negotiations with the construction company, and these 10 apartments, we had to find a way to get around it. Well, at that time, we had the idea to use maybe those apartments as service housing. However, we didn't find the right legal way to assign them to the prosecutor's office as service housing, and we had to distribute those leftover apartments to other prosecutors. So throughout 6 years, while the construction was underway, there would be other applications filed and they would be looked into. And depending on the possibilities, the apartments would be distributed, or this right would be granted to other prosecutors who initially didn't have such a right to invest in constructions.
All right. Thank you very much. The second criterion that we were talking about was the issue of the fact that the prosecutor participates and through the construction of the housing complex through their own investment. Does that mean that the prosecutor, him or herself, had to participate, or was that a family investment? Was that also allowed, or how did the commission apply that?
The commission did not impose any such conditions as to who is to make such payments. What is more, the commission, as far as I can remember, by the announcements that it published for future beneficiaries, it actually guided some prosecutors and family members who were supposed to use this right. So it guided them so as for the money to be paid by transfer as well. The parents of many prosecutors used to work abroad, and for many apartments, the payment was made via wire transfer. Special accounts were opened for that purpose with a construction company, and they would take this money by transfers. They would receive this money by transfers from abroad. I remember they opened an account in foreign currency and one in Moldovan lei. So one could make payments of installments. One could pay the installments for the apartment. I think it was altogether 5 installments. So one could make a wire transfer to pay for that, or to pay directly at the cash desk of the construction company.
Okay, yeah, thank you. And then the third criterion talks about respecting the principle of transparency. What was meant by that, and how was that applied by the commission?
As regards transparency, or rather the principle of transparency, that was a principle applied equally to all. Or, to put it in other words, everybody had responsibility for the truthfulness of the information they submitted, for the accuracy of the documentation submitted to the commission as regards the members of the family, as regards the health conditions, as regards the spaces, the housing spaces they had, or as regards the real estate they owned, and so on and so forth. So there was a condition of transparency imposed on all. What is more, the condition indicated that it was going to look into the information submitted by the future beneficiaries, potential beneficiaries of this right, and like if it had any questions or additional inquiries, it would address them if they had any questions to those who submitted their applications.
And my last question, but maybe other members of the commission have other questions as well, is so you were earlier talking about the issue of preferential housing and how you explained that. But if we are looking at the situation that at that time a plot of land was provided from the Chisinau municipality to the General Prosecutor's Office in order for the construction of this complex of apartments that was donated. According to our information, if that plot of land would have been on the market, it would have been sold at that time for 5 million lei. You also explained that the commission was involved in the identification of the company to construct it, and it was really focusing on what the total costs were. So all in all, it would mean that anyone who participated in this program would, in principle, get an apartment or buy an apartment for a lower price than would have been the case if the full market price would have been applicable. Is that correct? Is there such a distinction to be made?
Eu vreau să vă spun și încă o dată
I would like to say, to make sure that you understand me right, these two programs, there are two programs. They were meant to provide prosecutors housing space. And the basis of that was an understanding of the actual situation on the real estate market and an understanding of the legal framework as far as the prosecutor's office is concerned. And that made it possible to launch such programs. So the City Hall, the Municipal Council of Chisinau, as managing entity of some land plots that were not used in any way at that moment in time in the radius of Chisinau, they gave that land away for use purposes, not for ownership, not as a gift, but for use, for certain purposes. So we, in 2005 or 4, or maybe even 2003, we filed a number of applications in this regard to the Chisinau Municipal Council in an attempt to solve jointly the issue of housing. It was already clear at that time that when it comes to municipal housing, there was not enough to respond to the demands of prosecutors in order for them to acquire, for instance, service housing. There wasn't enough of that. And at that time, we thought of this procedure. We were never owners of that land, never ceded that ownership right to us. So as regards that land, in the deed it said that it was handed over for use. It is under the management of the Chisinau City Hall, but for a while, the right, or rather, we were just given that land for use. But further on, after the complex was built, on the basis then of the law on condominium, on that land plot that the building was erected on, there was an association of condominium established. And in addition to the blocks of flats built by that construction company, the land associated with it was also included there. And the associated land, according to the law on condominium, was appropriated by the City Hall. Now, to make a distinction in that regard, or for me to be able to make an evaluation of that land plot as to its cost, how much it would have costed on the market in terms of sale and purchases and the price of it, it wasn't something on our agenda. What is more, the prosecutor's office, the institution itself, never had the intention to purchase or to have ownership right over a plot of land with that purpose. So the only condition was, or the only thing that happened, it was that it was appropriated for use. And we tried to make the best use of it to make sure that we can provide housing to as many prosecutors as possible. So out of 600 apartments that were built there, prosecutors, there were So this right to property was given to 250 prosecutors. So about a third of those apartments, a bit more than a third of those apartments went to prosecutors. The rest was sold by the constructions company, and they incurred on their own all the expenses related to construction, the paperwork, the making that building available for use, and all the connections for utilities and all that. They took that on themselves. So I don't think there is a correct correlation between the market price for the land and the market price of an apartment. We never followed that train of thought. Maybe that makes sense, that might have made sense, but we didn't mm, approach that like that. So the commission, the institution, we didn't look at it like that.
Okay. I have no further questions. Are there any members of the commission who would like to have a follow-up question? Yes, Nadezhda, and then Victoria. Go ahead,
Da.
Nadezhda.
Domnul Pascal, bună seara, vă mulțumim mult pentru răspunsurile
Good
acordate.
evening, Mr. Pascal. Thank you for your answers. I would like to clarify something. I'm not sure I caught that right. So this program that you referred to, if a prosecutor stated that they want to buy one of the apartments that were available under the program for their sister who is an adult, or for their brother who is an adult, for instance, and technically speaking, from the point of view of law, that person is already part of a different family, then you were secretary, but still the commission would give an apartment to that person or not? I can't answer this question because we examined all the applications through the lens of a phenomenon, that is the fact that prosecutors didn't have the possibility on their own to purchase an apartment on the basis of mortgage conditions. They wouldn't have been able to afford real estate. And I can't imagine them coming and saying, give me an apartment to give it to somebody else. Now, what they did with the apartments after they've acquired them, no, I mean when, for instance, they file an application, if they wrote, considering the principle of transparency, I want to buy this apartment, or I apply for this apartment, who is intended for my brother, who is, say, 18 or 19, for instance. Or if you can't answer hypothetically, can you remember of cases where the commission granted or allowed such apartments to adult family members of prosecutors under these programs that you referred to? Thank you.
Vreau să răspund la întrebarea dumneavoastră, dar
I want to answer your question, but I don't understand, or I can't be explicit enough. Once more, on the content of a project. It was one project for prosecutors and their family members. That's all. That is my answer to your first question. And if, hypothetically, someone could have come to ask to benefit of this right for someone else, I think that obviously it wouldn't have been granted. But we did not receive such requests. What they did subsequently, the prosecutors who benefited of it, what they did with their rights over those apartments, that wasn't one of the general tasks of the commission. Thank you very much. Mr. Pascal, last question from me. You answered several times, and I just want to understand. When you say family members, that includes parents and children. Do I understand you correctly? Like common household and dependents. There are some situations where, depending on some situations, you could have a dependent, like, I don't know, elderly parents or grandparents that can't live alone where they are. They can't take care of themselves. Okay, thank you very much.
Thank you. Yes, Victoria, you have a question. Go ahead.
Yes, thank you. Just for a little clarification. I understand that when prosecutors applied for the program, they furnished information. Was there an application form, or did they provide information on their own? How did they know what to provide?
Instituția avea un sistem
The
informatic
institution had an interinstitutional information system among all the subdivisions. I think it was called ACCESS. It was created to ensure a speedy transfer of data. In that ACCESS, for the first time, information was published about starting such a project, and that's where the following was written. What a prosecutor has to submit. The application itself was free form, no template provided. Just it was requested that the application should be accompanied by confirmation documents that prove, for instance, lack of housing or having housing but with a family, how many members and how, and obviously the health condition if appropriate. So of course this information was this list was not comprehensive. They could have provided even more information if the potential beneficiaries thought that could have influenced them getting or not getting that right.
Yeah.
One other question. I think you mentioned earlier when Mr. von Hebel asked you what type of checking was done by the commission with respect to the applications, that efforts were taken to verify the contents of the information. And I think you mentioned that one of the things that the commission looked at was whether the applicants, the candidates, had applied for or participated in other programs. Did I understand that correctly?
În primul rând, până la asta,
First of all, before this program, there was another one in Ciocana, that is one sector of Chișinău. Around 140 prosecutors benefited of that right previously in 2007-2008. And of course, people who have already gone through that program and obtained housing in a different project, in the previous one, that was also carried out in Chișinău, those people did not have the right to apply again. From the very beginning, the commission excluded the possibility to assign housing to the ones that obtained the apartment in a different program. Certainly, we did that.
Okay, and that first program, which I think you said was in Ciobanu?
Ciocana.
Was that also a Baskin Lux project? Was Baskin Lux also instructor on that project?
No, it was a different company. I was not part of that, not as a commission member, not as a secretary. And unfortunately, I did not benefit there of any information. But certainly it was a different company.
Okay, and yeah, I think that's all I have for the moment. Thank you.
Okay, thank you, Victoria. And Nona, please go ahead.
Greetings, Mr. Pascari. I have a question concerning the land plot. You mentioned that land remained as a state property. And I have a question. Because of this assignment of the land, the price of the apartment was lower, and it was not sold according to the market price. So, what's the difference? Why you pay special attention to the fact that it was still as a state property, as it has impact on the pricing. So why you did not take this fact into account?
Deci, după practică, companiile de
According
construcții
to the practice, construction companies were purchasing at tenders. They were buying from the local public authority, in our case, Chișinău Municipal Council. They were getting somehow the land plots, and of course, I believe that the price of a land plot could be reflected to some extent in the future price of an apartment, or a part of the cost of the apartment would be representing the price of the land, only with the condition that the land plot was purchased. If a developer invested money or the construction company invested money in the land plot, in that case, such a formulation may be right. But in our case, because we obtained only the right of use for this land plot with the permission of a city hall, we started the project to provide prosecutors with housing because we coordinated these things with the city hall, starting the construction, obtaining urban planning certificates, construction permits. That land plot, in the end, stayed in the municipal fund, land fund. I believe that later on, when it was put into operation and when the condominium was created, it has been distributed as a adjacent or land plot that is necessary for the management of a building, because that complex consists of 8 buildings, like built in a circle in a way, round.
So actually my question is, because of this right of use of the land, the price of the apartment for the prosecutors were lower compared to the market price. So since the land is public property, so there was some contribution from the public to the program. So this is what I want to understand, because the fact that land remained in a state property it has no particular bearing in this context, because there was a contribution from the public to building to build this housing. Do you agree with this assumption, or it's not that you had in mind when working on the programs?
Nu sunt de acord și vă spun de ce.
I don't agree, and I will tell you why. If we follow the idea that you expressed, then the city hall should have also benefited of some apartments or a share of the apartments built there. The city hall should have get it as a share of it because of providing the land plot that is or could be municipal property, but that did not happen. The city hall did not benefit of an increase in the housing stock of the city hall. The city hall did not get any apartments there. This was done only in order not to allow to block the activity of the city hall, because there have been such attempts when prosecutors or the ones who could or needed improvement of their living conditions as housing, apartments, they were going to court. And the city hall, in some cases, was sued in court for not enforcing certain decisions or writs of enforcement. So we had such cases before. And maybe I'm mistaken, but there have been cases when the right to provide a person with housing, it was replaced by providing him money, if I'm not mistaken. That is legal. And if this has been subject of some criminal cases too, but that was long ago. So I am not sure about this, but I know that such information certainly was there in the public space.
And the last question on something else. Were you also the member of the commission, or you only served as the secretary? Because in your discussion, sometimes you mentioned we decided, so just to understand your exact role in the commission.
I was member with the function of a secretary because someone had to ensure the activity of the commission, to summon meetings, to keep secretariat work, and that was me. So I was a member with a right to vote.
Any other questions there, Nono? Anyone of the commission? Are we happy with all the answers? Then, Mr. Pascar, I would like to thank you so much for being with us. And sorry, Victoria.
I believe the candidate has the right to ask questions.
Oh, yeah. You're right. Thank you so much for answering at least all the questions from the commission. And then I would like now to give the floor to Mr. Codreanu to ask any questions he would think on top of our questions that are relevant for our assessment. So, Mr. Codreanu, please go ahead. Your microphone, Mr. Codreanu.
Așa e bine?
Yep.
Ok.
Yep.
Domnul Pascal, bună seara deja.
Good evening already, Mr. Pascar. Tell me, please, City Hall, over the years, since 2009 and until now, did they have any complaints about the allocation of that land plot towards, I don't know, General Prosecutor's Office or towards the construction company, generally in relation to that project? I don't know. But in what context? I don't know. Maybe somehow claiming for some payments for that allocation, or for the fact that that land plot is being used by the condominium. I want to understand if there are any local public administration expenses incurred as a result of allocating that land plot, and since it is being used for the construction and for the living of people, of prosecutors. Until 2017, certainly there have been no complaints from the City Hall. Moreover, we had quite good cooperation with the City Hall in order to make sure that the construction works are completed and the prosecutors are provided with housing. No, we did not have any problem. It's not clear to me if institutions' money was used. Prosecutors General, the Prosecutor General Office, being a public institution and being funded in its work based on the budget law, from what I know, there are certain lines or areas for public expense, and allocations of this kind it did not have. Moreover, the prosecutor's office has never set as a purpose to use public money for building housing. No such projects happened, and from what I remember, such financial possibilities were not even looked into. The prosecutor's office has only the role of an intermediary or an entity that was guaranteeing to some extent potential observance of rights and completion of the intent to allocate housing. The General Prosecutor's Office only signed the civil contract, so it did not benefit of apartments and did not allocate public funds. Tell me, please, did you have any appeals or requests, complaints from other prosecutors? We had complaints about the quality of construction works. From what I remember, there were even many written complaints, and some prosecutors moved on. I mean, not prosecutors, but family members of prosecutors moved on and appealed or doubted the quality of the construction. Tell me, please, have there been cases of migration of apartments from one building to another, particularly in case of this program of 2009, so that the location would be changed at the request of a prosecutor who accessed the program? I will try to correct you. Not migration of apartments. From the beginning, we did not allocate apartments. We tried to allocate the right to a person to benefit, with the right to invest. In this case, with the acceptance of the construction company, there have been moments when, at the request of some future beneficiaries, they accepted and the construction company allowed that some prosecutors who had stringent needs right now and right here to fulfill this right, to change the object of the apartment with the right of investment. To be more explicit, we built apartments for prosecutors on 26 Melestiu Street with Basconslux. At that time, Basconslux had apartments being built in Ciocana sector, that is one sector of Chișinău, and in Centru, in center, on Tolstoy Street. So these housing complexes that were already built and put into operation. The company accepted for it to take over the right of the apartments that prosecutors were supposed to get on Melestiu Street, giving them the right at request to invest in apartments that were built and put into operation in the housing complexes in Ciocana and on Tolstoy Street, according to the same conditions, 340 euros per square meter, following or respecting the square footage of a number of rooms, with the condition that the payment would be made at the request of the construction company in full, not in installments as it was allowed for the complex to be built on Melestiu. But since the buildings were already finished and put into operation, they had to pay the full price. Such cases existed, I think. Tell me, please, the investment contract. Now, when were they concluded, speaking of the construction complex from Melestiu? What year was it? Well, the commission was established in end of 2009, somewhere in 2010. Yes, in 2010, in April, the first contracts were concluded for investment in construction through a mortgage mechanism, and they were authenticated by notary between the construction company and the future beneficiaries, prosecutors and their family members. That was our condition. set by us in order to guarantee the fulfillment of the contracts by the construction company and not to allow setting those apartments as collateral or as security. At that time, the law on cadastre, 2 articles were added, 40 and 5 and 46. It was possible to register your future right for real estate. So we followed, upon the recommendation of a notary, we followed this method, and future owners, beneficiaries, prosecutors or their family members were got registered their future rights on those housing spaces, and they were getting temporary cadastral numbers for the apartments. Tell me, please, when this change of location happened, you said in some cases it was accepted. What type of contract was being concluded, or in what way that contract? Were the contractual terms different? Was there a different type of a contract, or was it the same type of contract valid for both complex on Melestiu Street and for the one on Mircea cel Bătrân in Ciocana? I can certainly say that the Commission developed the draft contracts for prosecutors with the construction company and with notary authentication for Melestiu 26. They were all signed by prosecutors. What kind of contracts were signed subsequently by prosecutors or their family members who benefited of that exchange? I don't know. I can't know, and it wasn't up to the Commission. The Commission just accepted change or permission to benefit of this right here and now, in case if they had the money or had stringent needs, as appropriate. But we did not manage, we did not have access to the same contracts that these beneficiaries concluded with the construction companies. The only condition was to follow the same price, same square footage. Tell me, please, could you please explain the situation when this thing is uncertain for me too. The contract that I concluded with Basconslux according to this program is dated 2018. 2008. No, sorry, indeed, 2008. Thank you. But the contract that it same also I did conclude with Basconslux for the same real estate was dated 2010. So I have 2 contracts from Basconslux with respect to the same real estate. I can't answer your question for the reason that I can state certainly that you signed a contract with Basconslux in 2010. That was a transparent, mandatory procedure for all future beneficiaries. What you signed with the date of 2008 with Basconslux, I can't say, but I can only make an assumption. Maybe you signed with Basconslux a contract where, well, they did not take into account the date. Maybe it was a technical mistake. As a lawyer with skills in this field, that maybe that can be checked, or it could be confirmed by the stamp applied by the cadastral body. Every contract is registered with the cadastral body. So, and it is in force as of the moment being registered with the cadastre. That's what the civil code says. The right of ownership arises when it is registered appropriately with the cadastral body, territorial cadastral office. I would like to ask you a specific question. So far, you were answering general questions, but in my case, it was discussed repeatedly, and that is an issue addressed by the Commission. The fact that this apartment, from the beginning, at the moment when I filed the application to take part in this program, was meant, had the purpose to be for my sister, given that we were living all together. For the Commission, that issue would have been a problem, or would this thing be a reason to refuse to accept my application in circumstances where I pay for it, but my sister was going to live in it subsequently? To shed light onto this question, I don't want to take any obligations or to make some findings, but I can certainly say that the applications that were filed, you, as an applicant for that right, certain reports were issued confirming or denying the right or the need, and our obligation to include you in the list of beneficiaries. What you did next with that apartment, or how you managed it, or who you considered the right to, the Commission had no such competence in its work, and we found that much later. That may have been an omission in the work of our Commission, but that's how it happened. I cannot say directly. What about a personal opinion, if you may? Mr. Codreanu, we had several. We have already had rounds and rounds around the meaning of the word family. We tried to establish in our discussion, is it possible for the beneficiary of the apartment to be someone else from the family than the prosecutor? I can certainly say that until the end of the construction, we noticed cases where apartments were registered not on the name of a beneficiary prosecutor, but on the name of family members, children, wives, or other members. Why I'm saying like that? I will give you an example. We had litigations that were registered on the right of subsequent ownership. That was the general condition when an apartment, when the future ownership right for it was registered and the proper documentation was drafted with the notary and cadastral office, if the family consisted of two members, husband and wife, it was registered as a 50-50 share for each of them. And if the apartment was sold subsequently, a consent from the second family member was needed in order to sell the apartment. So what I want to say, these apartments were meant for prosecutors and their family members. In this case that I was talking about, it for the wife. What was done subsequently, we did not check, and it was not up to the Commission. But there have been divorces. Some prosecutors, from what I remember, died, and there was a right of succession to the members of the family who had that right, or to family members who did not have it, right? So, because, I mean, there were prosecutors who had children and there were prosecutors who had no children. Moreover, there have been some dilemmas in the activity of the Commission where both husband and wife are prosecutors. Two prosecutors in a couple. That's the dilemma. Should they both be provided with housing or only one of them? So we had questions in that regard as well.
Spuneți, vă rog, dacă vă aduceți aminte sau
Can you
cunoașteți
tell me if you remember or if you know whether in cases where the locations were changed, whether there was a difference in terms of square meters and whether that difference was paid for the same preferential price or was it paid for at a different price, the one established by Bascon's Lux? Well, I didn't get into the essence of that, but as I can remember, the Bascos Lux company was indeed making a difference. If the apartment was 60 square meters, one room only like a flat, or two rooms that was larger. I can't remember very well the details of that, but Bascos Lux would ask for the difference to the in terms of square meters to be paid for, because they couldn't have apartment of that particular those particular square meters. They would be smaller or bigger, and where they were bigger, where the apartments were bigger, the market price would be applied upon this sort of if there was a swap of apartments, or when the full payment was made, they would have this difference paid for the market price. And my last question, well, if the price of the apartment was paid from the money of parents of the applicant, could it be an impediment to acquiring an apartment that way? We'd never had such a condition. And as I've said, there were cases when payments were made from abroad, for instance. If parents worked abroad, special accounts were created. But was that an obstacle? Could it have led to that being a reason to annul the decision to grant one the right to buy an apartment like that? It was no, it was only if the prosecutor wouldn't pay, or if the payments wouldn't be made, if the installments wouldn't have been paid, then that would have resulted in withdrawal. But as far as I can remember, no such cases happened. To be honest, I know that there were cases where this right was transferred. If they weren't able to pay up, they would cede that right to other people, family members, or even other people outside the family. Thank you very much. No more questions from me.
Thank you very much. And now, indeed, we then come to the end of the discussion that we had with you, Mr. Pascal. There again, I would like to thank you so much for being with us this afternoon and providing straightforward, open questions in all detail to both the candidate, Mr. Codreanu, and to us. I think this has helped our commission to a better understanding of the functioning of the commission. And again, I would like to thank you so much for being with us this afternoon. We will continue with a further discussion with Mr. Codreanu, but we thank you for your participation this afternoon.
Mulțumesc și vă spun cu drag, dacă
Thank you, and you're welcome. And if I was of any use and support, and if I managed to bring more clarity to the matter, I was happy to do that. Thank you, and have a nice evening, sorry.
Okay, then we still have issue number 2 to discuss with you, Mr. Codreanu. And I know it is late. It is 7:10, and I think it would be good to continue our discussion, of course. But I think I don't think there's anyone who's interested in an extensive discussion and continuation. So let's try to wrap up our work in a way that would allow us to get the information from you and for you to make the point to the commission. So briefly going to issue number 2, as I mentioned, that was related to the method of acquiring a 49.1 square meter apartment as service-based housing, which was subsequently privatized by your wife. So we formulated the serious doubt for you, and I will briefly quote it again. And it says the following: the commission has serious doubts about the financial and ethical integrity of the candidate with respect to the method of acquiring a 49.1 square meter apartment in Chisinau, a second apartment which the candidate became the owner as a result of his position as prosecutor. Serious doubts concern the different steps the candidate took to become the owner of the apartment, including the fact that he did not consult a notary to establish the legal status of the apartment, that he himself approached the president of the managing association of the apartment and told her what to include in a handwritten statement about the occupancy of the apartment, and the fact that the apartment was privatized by the candidate's wife at a nominal price, although it was meant to be a service apartment for the candidate because of his position as a prosecutor. End of quote. I would like now to give you again a maximum of 15 minutes to provide additional comments and additional explanations to complement your written response. Please don't feel obliged to use all the 50 minutes, but of course you are entitled to use them. I would like to give you the floor now, and then after that we may have some questions for you. But Mr. Codreanu, please go ahead. You have the floor.
Da, vă mulțumesc.
Thank you. My position is the same as it was at the first hearing and at the first rounds of questions. I believe that at that time, we're speaking about 2009, when I went to the Court of Appeal to claim that a right of mine be observed that was provided for in the law in the prosecutor's office at that time. I had the intention to have service housing, and considering that for a long period of time the local public administration was not able to enforce, to implement that decision, although the bailiff has sought it for quite a long period of time, and I mean for a period of 5 years, I find that when the opportunity, I found out that some information about the department, and I initiated this process in the due process in court, and all procedures that were identical, or that rather procedures that other prosecutors, whereby other prosecutors are provided such service housing. So in all procedures, they did this particular way. They went to a court, not to a notary, not to the state tax authority, as you mentioned in the doubts, and in the decision of May 2023, the decision that was actually annulled. The Commission referred to the provisions of Article 1515, and it showed somewhat that I was under the obligation to initiate the procedures by referring to that particular article. Now, I looked into that article because at that moment in time, speaking about 2009 and then 2014, when I actually took the case to court, specifically with regards to that apartment, that is apartment on Gradinilor Street. I did not know about the provisions of that article, but now, currently, I still don't see how that applies, and I don't see how the Commission could have said that there was lack of ethics on my behalf by not applying that article. And the article, if I may read it, and by the way, I don't understand how did the Commission reach the conclusion that that is the legal provision according to which I was supposed to go to a notary or to the tax authorities. And I will also make some reference to the court decisions. So, I asked him to slow down. So the property is to go to the government on the basis of inheritance over vacant property if there are no will providing for the successor, and if none of the successors accepted that property, or if all the successors are deprived of the right to this. Paragraph 2.
Da, scuze.
I asked him to slow down again because we can't keep with that. We don't have the article here. So the government is to take over this property, successful property, by issuing a certificate of vacant succession. And then this paragraph 3, again, that covers the way that this property is to be transferred over to the property of the state, and that is set out in the law. Either way, out of the provisions of this law, I cannot read out my obligation to inform the tax authorities and to take this case to go to a notary. In the process that I initiated in 2014, the court, at the request of the defender, has informed the Ministry of Justice, and it asked the Ministry of Justice to provide that information regarding the succession, whether there was anything going on in terms of succession around the particular property. Now, the decision of 2014, of 31 July 2014 that we are speaking about, that was adopted, including on the basis of that certificate that was made available by the Ministry of Justice that communicated with certainty that at the time that the case was in court, there was no certificate of succession or inheritance or any information regarding who would inherit the apartment. And the court took that into account upon handing down that decision. And all the instances, all the Court of Appeal in 2015, and the Supreme Court in 2015 too, when they looked at that case in a procedure of appeal and second appeal, they've established that the certificate proved that that apartment was not a successorial asset that was to be inherited by anyone. I would like to mention, I'm not certain, or at least the Commission did not mention this in any way about the fact that the bailiff, so there was a request of the bailiff and the court, and I mean the Rishkan court that looked at my application. They explained the way in which the decision was to be enforced. And that is something of great importance. The court decision was explained. Well, if I could read out again briefly to make it clear that the execution or the enforcement, the way in which the decision was enforced, it was not something that I came up with. It was not invented by me. It was not something that I chose, but it's something that the bailiff chose on the basis of that decision. Just a sec.
Da, mulțumesc. Este vorba doar de o încheiere.
So this is about, there's a ruling of April 4, 2015, where the court says that it is explained that for the purposes of executing the court decision of 31st of July 2014, whereby it allowed for the lawsuit initiated by Codreanu Vitalie against the State Tax Inspectorate, Chisinau Municipal Council, with regards to declaring that asset as vacant from a successor, referring to apartment number 123 from Chisinau municipalities, to declare it a vacant successorial property, and for it to be transferred over to the government, property of the government, with the obligation for the council to issue to Codreanu Vitalie a distribution order for him to move in an apartment 123 on Grădinior Street after the apartment is registered in the Register of Real Estate. The Chisinau Municipal Council is to issue to Codreanu Vitalie, to Codreanu and his family members, a distribution order for them to move in into that apartment. So that was the ruling. And it turns out that the state tax inspectorate was to take over that asset and to have it recorded in its registers and then to pass it on as government-owned property. And then there was supposed to be transferred over to the municipal council as property owned by the municipality. And that for the purposes of executing that decision of 31st of July 2014. That is what actually happened. That is what happened. And I provided that in the first round of questions. I provided the minutes that says that the state tax inspectorate is taking over that asset. There is a handover takeover report that shows that the asset then is transferred to the municipal council. And then there's a distribution order whereby I was attributed, I was transferred that asset. In all this procedure, I did not see anything with regards to any inaccuracy or that it was not right for me to go to court and have with regards to the way the court decision was enforced. I would like to mention that decisions of this kind, like the one that I had, I mean the one in 2009, the decision of the Court of Appeal, whereby the council was under the obligation to give me living space, well, that was actually quite burdensome for the municipality, because the municipality wasn't able to execute that, to make that happen. And I recently came across a decision of the European Court of Human Rights, a judgment of this court, and one of the members is from among the judges is Nona Tsotsori, and the government there reached an amicable settlement with Antoch Konstantin. And I don't understand what is the cause, what is the reason if I managed to present that apartment, to not just leave it up to the municipality, to the municipal authorities. If I left it up to them, then to this day still that decision wouldn't have been enforced, and I would have certainly had to go to the European Court of Human Rights, because the prescription time would have been, or the term of execution would have been far too long. In this case, the Commission puts it on me that I didn't observe certain requirements of the law. But then I asked the question, if I didn't observe the requirements of the law, then how could then Rashkan Court, the Court of Appeal, and Supreme Court of Justice, how could they have accepted my applications then? But I don't understand where my mistake is, and why is it that the Commission believes that I was unethical in terms of the provisions that the Commission referred to, that are provided for in the Code of Ethics of 2007 and 2011. I don't understand this. I don't. Although the prosecutorial inspection looked into this matter from the very end, from the very beginning to the very end, since 2009, and all the way till I registered the ownership rights. And this case was examined at the notification of the Prosecutor General. In 2018, I submitted all the documents required, and the inspection refused to initiate a disciplinary action against me because they established there were no deviations. The court found no issues with how I addressed the matter, and having taken the case to court, the General Prosecutor's Office found no violation in my actions with regards to that, to my applications, and with regards to obtaining the ownership right. Then was there any other legal way for me to claim a right that was provided for in the law at the time? Also, the Privatization Commission, it was said that the Privatization Commission accepted it, and that was also put on me. But the privatization, I would like to explain, took place in a situation where I submitted all the documentation. I submitted everything that I was asked to submit. Nothing was hidden away. I was very active, and at their request, I submitted the document that shows that I participated in privatization. Why the Privatization Commission decided to have that privatization decision specifically, and then the sale and purchase agreement was on the name of my wife, and I cannot explain that to myself. It was not a specific requirement from me. It was not me interfering with the work of the Privatization Commission. That commission decided that I had to submitted some documents and necessary documents. I submitted that. I was given the sale and purchase agreement. I went to the notary. I had it signed as I had this power of attorney from my wife. So look how so many courts and so many institutions were involved. I said that in the previous hearing as well, but this was not taken into account. All the national courts looked at it. The City Hall through the Department General for Housing Issues and the Deputy Mayor General, or the Deputy Mayor General who signed that contract, the Privatization Commission. Why weren't these? Because I keep reiterating it. This is all pinned on me. And I found that error that happened in this procedure. And that error was not because of failure to present some documentation, or it's not because of me hiding something away. There was an error that was produced because the Department General for Housing Issues, when they developed the order of distribution, they didn't indicate that that place was housing service, was service housing, sorry. Otherwise, the Privatization Commission wouldn't have admitted it, and I would have kept using that apartment to this day without it being a property owned by my family. Now, as regards the what was in the mass media that.
Just to briefly interrupt, This is already in the 14th or nearly the 15th minute of your explanation. I hope you can wrap up quickly. Thank you very much.
The articles and in the media, I presented that. I did not want to hide anything that was in the public space and what I had in terms of documentation, in terms of the views that I've also had. I know that some references were made to the statements of a woman who was the administrator of the Association of Residents there, but I would like to reiterate that I did not act in a fraudulent way in relation to that woman or to any other individuals or entities or to anyone at all, to any public people or positions at municipality level. And I still don't understand from the previous decision, I don't understand why were those violations put on me. I did not violate the law in any way. And the Supreme Court of Justice established that, and it actually showed that I acted in line with the law, and it is the strength of the res judicata of those other court decisions that is undebatable, although the Commission might raise comments about decisions of other authorities, but not of the Supreme Court of Justice. There are provisions of the Constitution that other colleagues have referred to the Constitution as well, and there are provisions of the criminal law that to somewhat protect decisions of courts. There is an article on the failure to implement decisions of courts, which is also a matter that makes that turns the decision of a court into a law, practically. I would like to refer to the decision of the Supreme Court of Justice of the 1st of August 2023 and the decisions of all other courts that looked into the litigation where the apartment was concerned, where I was a party. And a final conclusion, as I previously said, this litigation, this lawsuit is currently with the Court of Appeal. In December 2022, it was there was the Central District Court, and practically the court have rejected all the claims of the other pretenders in this process, the other parties in this process. Thank you. Over.
Thank you very much. And I have a few questions for you, and I will try to be brief as well. My first question picks up on what you were referring to almost towards the end, and that was your communication with the president of the association that managed the apartments. And according to an open source where she is quoted, she says that she was approached by you, that you urgently needed to talk to her. And that she declared to you that she did declare at the time that there was no one in the apartment, but that she did not declare that the apartment was without an owner. She also stated that she was exclusively Russian speaking and that you dictated her what to put in the handwritten Romanian declaration. What are your reflections upon that statement from this process?
Well, the answer is going to be very simple. I said it before, and I will reiterate that I am ready to be subject to any verification. And because I did not have any influence over that woman. I think it would be reasonable for the Commission to seek the explanations of that person. That interview that she provided shouldn't, well, some pseudo journalists conducted that interview, and I don't know if that woman was influenced by people who claimed that they were the owners because they lived in the same block. So they could have made any kinds of statements. They could have said anything in the world, to anything denigratory about me. I'm not sure the Commission can take into account some statements made in 2013 by a pseudo journalist in the presence of people who claim to be the owners. I would like to highlight that the Commission didn't ask for documentation from that woman, didn't ask for explanations from that person, and she was not invited here for us to be able to ask her when and where things happened. I did not influence in any way. I have admitted that I went to see her. I showed her the certificate that I had, and I explained in the previous hearing as well the logic of the events and of her actions are due to the fact that she received a request in the state language and she worded her answer in the state language. I didn't know who lived there. I couldn't have given her any information. I couldn't have told her what to write about the absence of any people there whatsoever. I couldn't have known if anybody lived there at all. And I guess this information is this is what she knew. She knew this information. She knew who lived there and who claims to be the owner or who claims to have the ownership rights. She couldn't have said that the owners are some particular people. She couldn't have said that because the owner of the apartment had passed away and she knew. And I would like to say that in 2012, this association number 82, where she was the administrator, it went to court against the deceased person, just for you to understand how ludicrous this is. And there is a decision whereby the court ordered the payment of debt for public utilities, I mean heat, and the amount was more than 12,000 lei. For that to be paid, the debt to be paid by a person who had already passed away many years ago. That decision was, well, that process began at the request of the administrator of that particular association. So then how could she have said that there was another owner if she knew from the very outset that the de jure owner, according to the documentation of the cadastre, had already passed away? I don't have an answer to this question. I don't have an answer to this, but it feels like these events are something that were manipulated by certain people. And I speak about the interview specifically. Those statements were manipulated. This is my personal opinion. And I do not want to force it on anyone, but I think that that person was was influenced into saying this by those alleged owners who live in the same block of apartments with her, and maybe they are friends and maybe even relatives by our traditions in Moldova. I don't know what that might have been, but there is no certain confirmed information that I influenced that person. There's only that interview that I made available, all the interviews that were even looked bad for me. I showed everything. I hid away nothing. I hid away no circumstance regarding this whole procedure.
Okay, thank you very much. But you do say that the interview, that was a speculation from your side, that she was influenced by others. Anyway, my second question is the following. You confirmed already to the commission that you never lived in the apartment that we are talking about, and that was due to technical conditions and state of the apartment. What do you mean by that? Was that because of the poor condition of the apartment, or was it simply because of the fact that the size of the apartment was not big enough for you and your family to be accommodated?
Domnul președinte, eu am spus-o în interviul precedent.
Chairperson, I said that in the previous interview, and I provided pictures from that apartment, the condition it was in. It wasn't an issue of size of square meters. No, it was a 49 square meters apartment, I think, for a family of 3 members at that time. That was absolutely okay, but the apartment was in a deplorable condition. When I entered it, I couldn't believe that people with a full intellectual capacity could live in such conditions. There weren't even minimum living conditions. Everything was in mildew. The flooring was taken out. It was like concrete on the floor. The kitchen was all mold and mildew. The children's room was like empty down to the wall. Probably the ones who lived there used the apartment but did not ensure any maintenance, and there was no hot water. The sewage was absolutely destroyed. There was no toilet available, and at that time I didn't have money to invest. Moreover, I thought it is not reasonable to invest and improve the conditions because I was having a litigation. This litigation that was solved in 2022, and the decision from Rashkan court that I submitted, it lasted since 2017. So I thought it wasn't appropriate to invest in that apartment because I did not know how that lawsuit was going to go. Maybe the court would annul the City Hall Acts, and I would have to return that apartment to give it back to some people. So I thought it was not the case to invest in that apartment. It
Okay,
wasn't the
I
case
think
for
that
me
is
to invest 10,000-15,000 for some repairs.
I think you answered my question.
That's
I
my
have no further
explanation. It's
questions.
only about some rationale.
I hear you. Are there any other? Yes, I see Nadezhda. Please go ahead, Nadezhda, with other questions.
Da, mulțumesc. Domnule Codreanu, eu am doar o
Mr.
întrebare.
Codreanu, I have a clarification question. When we asked you about what did that president of that condominium declare, we meant the article published by Ziarul de Gardă in 2018. Did you make reference to that same article? Not. No, Ziarul de Gardă took over the information from crime.md. The first information, so to clarify, I just want to clarify. The question was strictly about what the lady declared, that you dictated her what to write because she doesn't speak Romanian. Is this what you calling manipulative information? Do you contest it? Yes, I do this, among other things. Strictly talking about the declaration of that lady, yes, I do. So you still hold that she wrote the text on her own in Romanian? Yes, she wrote that. She would admit that to a journalist because she does not speak Romanian. She does not speak, but who wrote it? She says you dictated what to write. How quickly? Do you admit that you went to her? Yes, yes, you took her by car. Yes, that is right. I said that during the first hearing, and I affirm that now but you didn't dictate. No, I did not dictate. Nothing at all. Thank you. The second question. You made reference to the ECHR decision that is about non-enforcement of failure to enforce a court decision. You gave very comprehensive answers about the fact that the apartment for which you had the litigation for a long time was uninhabitable. The question is, why didn't you go to ECHR, as you could have done, to obtain the enforcement of a decision you had? Why did you take so many years for litigation for an uninhabitable apartment? For you to understand me, I did not go to ECHR because I couldn't. I did not have legal reasons to go to ECHR because the national courts accepted my request to get living space. The conditions of the apartment, so when I lodged the application to court, I did not know what the condition of the apartment was. I could not know if the condition of that apartment would allow me to settle in immediately and live there. And I don't have the impertinence to go to ECHR for the fact that someone to make repairs in that apartment. Please understand me. It was enough for me that my request about that apartment was accepted, and over time I would repair it and live with my family. It's simple as that. So these are different situations. Because I did not understand your reference to that decision. That's why. Well, the reference was made for you to understand that the issue with apartments That was an obligation of the state. Well, of the to better put it, it was an obligation of a local authority. It's been on the docket of courts and decision makers for long years, for many years, and this matter made or led to the exclusion of this provision from the law, and it was excluded in 2009 or 10. And I'm making reference to it, trying to make you understand that you somehow charged me for the fact that I helped the municipality to fulfill a decision of its. You did not ask the question why they failed to enforce it for 5 years, because the issues with apartments were also on the shoulders of the ones who had these orders to give apartments. The municipality never did that. They never ruled in favor of the ones who had these decisions to enforce. And I can tell you that even until today in Moldova, we have writs of enforcement, or the municipality has writs of enforcement that are not enforced, coming back from 2003, 2004, and until 2009, specifically in relation to such rights. And I'm sure that such matters will continue to be examined in ECHR, among other things. So I just mentioned that as a suggestion for you to
Ms.
understand that even
Codreanu,
a member of the commission had on its list such a issue.
yeah. Mr. Codreanu, let's not discuss the possible cases before Strasbourg. Let's discuss our case here. I see Victoria Henley and
Așa
then
am fost întrebat,
yeah.
mă scuzați.
So Victoria,
That was the question. That's why I answered.
Victoria?
My question is, when you applied for service
Laura.
housing and ultimately received a decision that was upheld by the
Da.
Chisinau Court of Appeal, stating that you should be given service housing, was it your understanding at that time that if you were given service housing, that you could have that property privatized?
Da. Și eu am spus-o în prima rundă din...
Yes, and I said that during the first hearing, first round of questions, sorry, and in the first hearing. Thanks to the commission and questions from the commission, I understood and I studied the legal framework from which it was clear that service housing cannot be privatized. And then, during the first hearing, I told you I studied a decision of the Constitutional Court in that respect that somehow was supporting the position provided by the law on privatization in Article 17, which showed an exception from the rule of privatizing housing. I did not know. Should I? Well, if I knew about it, I probably wouldn't be talking to the commission about it. But again, if I had no such right, why the privatization commission accepted that? And actually, I answered that question. I showed the commission that I was quite active, and I also wanted to find out an answer to that question when I submitted a request to the privatization commission so that they could explain to me why that happened. And the commission explained that this privatization was possible for one simple reason. In the allocation order, it wasn't said that this was service housing, but that was not a problem that would be up to my competence and duties. Despite that, the evaluation commission, the preventing commission, said in the decision that I am the one to be blamed in connection to this not having the right to ask authorities for that. The mistake happened when the allocation order was issued, and at that time the General Housing Department should have found that, according to court decisions, this allocation order should have included housing, service housing in it. This was not something that I provoked. I was absolutely open. I submitted all documentation that I was asked for to all local authority bodies, General Housing Department, Privatization Commission, and the deputy mayor who signed the contract. I did not understand why the commission believed that I did not proceed in an ethical way here. In my opinion, the code of ethics and deontology are quite slightly different from this specific case. And the Supreme Court of Justice, in its decision of 1st of August 2023, held this fact and said in clear terms that in this case, there is no serious doubt, and I did not act with ill intent. And in none of the court decision, it would be mentioned that I had any ill intention regarding that apartment that was privatized.
Okay, thank you then. But then I have my very, very last question, and that is the following. If you applied for housing, you applied for service housing, and you get a distribution order by which the word service does not appear, although you know it should have appeared in that decision, do you then think it is ethical, knowing that it was meant to be service housing, that you continue and get it privatized, knowing that privatization cannot apply to service housing, and knowing that the privatization had to take place in the name of your wife rather than your own? Do you think that to be an ethical way of action?
Mai explic încă o dată.
I will explain once more. About this prohibition to privatize, learned only in the Commission's question in 2023. I did not know about that. Now, well, as I found it, I can't contribute to correct this situation, but this is not an issue that could be put on me. I did what the Commission told me. I submitted them the documents that they asked for, including, and I don't understand why the Preventing Commission doesn't want to take this into account, including the document that confirmed that I took part in privatization. I did not tell them on whose name to privatize the apartment. They chose that the privatization would be done on my wife and child. It wasn't me who chose the procedure. I did not suggest it. They just told me to come and pick the decision of a privatization commission. And then from the general housing department, I was told that I have to go to the notary to sign the contract. That is all. I did not do anything to hide the document. And in the case file of the privatization commission that I submitted to the Preventing Commission, you can see the certificate that I took part in the privatization in 2014 when I was a minor. I took part in the privatization of my parents' apartment, family apartment. I don't know why the privatization commission chose that opportunity for our family, so that the privatization would happen on my wife's name. There is a logical explanation. My wife has not privatized any good by that time, and probably the commission believed that the wife can privatize, or in that case, there's no legally provided prohibition to take part in privatization. And by the way, for the sale price of the apartment, it wasn't me who established it. I came and I paid because the evaluation commission mentioned that there is some suspicion about that price. It wasn't me who established the price. It was the General Housing Department, or specifically the subdivision that drafted the sale purchase contract for the apartment signed by the deputy mayor of Chisinau. I did not establish the price. They gave me the contract, they told me the price. I signed and I paid.
Okay, thank you very much for that explanation. I think with that, we come to the end of the hearing. As per usual, I would like to give you the opportunity to make a brief closing statement if you would like to. If you would like, indeed, please go ahead, Mr. Codreanu.
Da, foarte, foarte succint. Eu sper că...
Very briefly, I hope that the Commission will take into account the explanations that the Supreme Court made. But given that the Commission invited me to a hearing today and did not issue a decision, I believe that the Commission did not perceive those comments of the Supreme Court in its decision of 1st August 2023. Regardless of that, I would like to state once more that during this process, I have been cooperative, open. I did not hide any event. And it's still very unclear why the Evaluation Commission does not take into account as an evaluation criteria the fact that the candidate was proactive, provided documents, was responsive, and all availability of providing documents and explanations. I expressed that. I repeat this once more, but this process that I believe is quite complicated, during it I made many requests. I think I counted, more than 20 requests to various institutions. I was looking for documents. I submitted, well, the ones that were possible, I did submit. So, and 80% or 70% of this case file are the documents that I submitted. And the decision of May 2023 that the Commission adopted to fail me was based only on the documents and information that I submitted, including information that was in the media. And then I asked myself at that time, what was the purpose of me being so active and honest and responsive to what the Commission was asking? I saw now the contribution of the Commission, a more active or a different one compared to the situation before the adoption of the Supreme Court decision. The Commission made made more requests to authorities, and almost in all cases the authorities said that they don't have documents available, but I tried to submit documents, even the ones that authorities don't have. And I hope that this criterion is to be appreciated. I hope another thing that will be appreciated is the situation that I shared about that declaration from 2012, where I did not declare the real estate. And please accept that explanation, from which it results that my action were without intent. It was imprudence. And dear Commission members, if you decided regarding some candidates to find arguments on decrease of certain prices, on certain circumstances, I hope you could, I hope you can give a fair and objective appreciation to evaluation of my candidacy. I think it should all start from the candidate's intentions, from the experience of the candidates, from the actions that we undertook in our life, intentions that guided us in performing these actions, the period when actions were taken. And I want to reiterate everything I said during this investigation is back from 2009, 10, 2013, and the apartment in 2016. I did not have violations. I did not have problems with the code of ethics. I did not have any problems with the prosecutor's inspection in my work. And as a final point, and I think that is the most important in everything that the Commission does, the evaluations you carried out, including about myself, were, I think, that made the society and the participants to certain processes to see me as a prosecutor without ethics. And in conclusion, the Anticorruption Prosecutor's Office, the subdivision that I'm part of, investigates the most complex and high-profile cases from Moldova. Never happened in the history of Moldova before. And in these cases, we, the anti-corruption prosecutors, we make a lot of effort. And when someone comes with accusations on lack of integrity, both financial and ethical, or either of them, I am going to those proceedings, and I'm not sure if the ones in front of whom I'm coming see me as a person that can take part in the act of serving justice. At least, should I be a justice seeker, I wouldn't want and accept for justice to be carried out by a prosecutor that is declared to be unethical. And this is a public declaration, and you know, this somehow endangers our career, and not only in this case, since I'm part of this competition to become a member in the Superior Council of Prosecutors, it affects very much our career, but also my profession as a prosecutor.
All right. Let us wrap up here, Mr. Codreanu. I think
Ok, vă mulțumesc foarte mult, mulțumesc că m-ați ascultat.
Thank you very much for listening to me.
Okay, thank you very much. Let me emphasize, of course, that we will take into account all materials that have been submitted at the initial evaluation, also during the resumed evaluation, the materials that you presented, the discussions that we had today, including also with the person that you suggested to be heard and which we did hear. Let me also emphasize that the focus of the Commission is only on the ethical issues, on the financial and ethical integrity. We do not pronounce on the professional status of any candidate. The only thing that we do is look at the ethical and financial integrity of a candidate for purposes of election, in this case, the Superior Council of Prosecutors. That is the focus, and that remains the focus of our work, obviously. With that being said, I would suggest that we come to the end of the hearing today. As you know, the Commission will withdraw now for deliberations, and we will prepare a decision based on all the materials that have been presented, and we hope to issue a decision within a month after the date of this hearing. I thank you again for being with us today and to listen to all our questions and to provide all answers. And I hereby declare this session closed. Thank you very much.